Oyez, oyez, oyez. All persons having business before the Honorable United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3161, United States of America versus Roman Sterlingov, appellant. Mr. Ekman for the appellant and Ms. Elkinson for the appellee.
Good morning.
Good morning, Your Honors. If I may reserve 3 minutes for rebuttal.
You sir, you ready?
Yes, may it please the court. Article 3 of the United States Constitution and the Sixth Amendment to the United States Constitution require that all criminal trials be tried in the state and the district where the crime occurred. It's not optional, it's mandatory. And when you look at count 1, in this case, which is a conspiracy to money launder charge, in the indictment, there's no reference to anything happening in DC. And I think what is astonishing about this case is that there's not a single piece of evidence anywhere in the record after a multi-year investigation starting in 2014, 2015, after almost 2 years of pretrial proceedings, there's not a single piece of evidence in the record showing any kind of conspiratorial act in the District of Columbia. Nor does the government point to any in its opposition brief. What the government relies on for venue in count 1 is count 2's sting representation. The court may recall that the sole act alleged in the entire indictment as happening in DC consists of a November 2019 mix through Bitcoin fog by an IRS criminal investigator in the District of Columbia. That government agent is not a co-conspirator, I think by law and also by the fact that that agent is not listed in the government's bill of particulars listing conspirators. So that can't be the basis for count 1's conspiracy to commit money laundering in the District of Columbia. Nowhere else in the record, anywhere, after a 3.5-week trial, is there any evidence of any conspiratorial act, any conspiratorial communication, or anything in the District of Columbia.
If Mr. Sterlingov had, the agent sent a message about how could I trust and rely on Bitcoin fog that was not responded to. If, and this is clearly a hypothetical, but if Mr. Sterlingov had seen the message and responded to it, and then everything's the same, sent the money.
Yeah.
Would that make a difference?
Yes, I think it would make a huge difference.
Would that make venue proper in DC?
Yes, I do think, yes, I think it would. And I think
the real question for venue.
No, I'm sorry, Your Honor.
No, I'm sorry. So the real question for venue, it seems to me, is whether a reasonable jury could have concluded on this record that Mr. Sterlingov saw that message.
I think for count 2, and I think that's a fascinating question about count 2, because when I did my research, I looked for cases involving, sting representations like you have here, where there wasn't any knowledge on the part of the defendant or any co-conspirator of the message. And I couldn't find one. Like every case I look at, there's either knowledge on the part of the defendant or some sort of co-conspirator. What's fascinating about, I think, this case and why it almost looks like a law school exam is that there's no evidence that the message was ever seen or
so my hypothetical, taking my hypothetical now, if we're focused on whether a jury could have found that he saw it, and then the money was sent. That would be relevant to the conspiracy count as well, would it not?
No, because that's not an act in furtherance of the
I thought I'd asked you if he had seen it and responded, whether that would take care of the venue issue, and I thought you said yes.
Well, as the court knows, venue has to be proper for each count.
Okay, so I'm sorry, because I thought we were talking about the conspiracy count. Why wouldn't it be relevant to the conspiracy count as well if the conspiracy is to operate this Bitcoin fog business and the whole premise of the way it works, to obscure identities, whether privacy or to protect against prying investigative eyes, is that money comes in and gets mixed and lost in the shuffle so nobody can identify which Bitcoin came in and which went out. And so it seems to me that everybody who puts, every time they accept more Bitcoin to come in. So every time those who organize Bitcoin have a situation where money is invited in. Every payment in is part of advancing the conspiracy because it increases the size of the pool of Bitcoin funds that are shuffling around and obscuring identities.
Well, the charge, as I understand it, is conspiracy to money launder and substantive.
That's the money laundering, is money coming in. And if money didn't come in, you couldn't money launder. You have to have, I'm sorry, I'm calling it money. Bitcoin came in. You can't money launder unless there's lots and lots of Bitcoin coming in from different sources.
But the mixing per se is not illegal. At least that's what the district court said. So there's entirely legal, legitimate uses.
No, I know there can be,
for mixers.
For mixers, but not for Bitcoin fog. And so if its whole purpose was this is the jury determination here, that it was used for money laundering, maybe not exclusively money laundering, but it was used for money laundering. And the way it was is Bitcoin comes in from many different sources. So when Agent Price's Bitcoin came in, it became part of the mix that obscured the identity of criminal Bitcoin that was coming in.
But that's not an act in furtherance of.
It seems to me it's an act essential to the conspiracy. If you don't have Bitcoin pouring in,
No, because
the money laundering can't work.
the Bitcoin fog was functioning without Agent Price's mix.
Well, you could say that for any individual one, but for every individual, it is part of the plan, is that we will have money Bitcoin again coming in from multiple sources, and that's what will allow the mixing to obscure and hide those either who want their privacy and or those who, for legitimate reasons, or those who want their privacy and identity hid for illegitimate reasons, the money laundering.
Yes,
But you could say that with any one, you could say that lots of times in conspiracies, the conspiracy would have kept going except for drug sale 12. It would have kept going. It was fine. That didn't really make it come or go. But every drug sale that contributes to a drug conspiracy is part of advancing that conspiracy. So to hear, if a jury were to find that your client, Mr. Sterlingov, had seen that message and nonetheless sent Bitcoin to Mr. Price, then his contributions, that inviting that in and sending it back, sending new Bitcoin to him, would have advanced the conspiracy in that moment.
I respectfully disagree on that, just because the Agent Price wasn't a co-conspirator, and nor was his conduct essential.
No, but it advances the conspiracy of others.
There's a big question of what conspiracy. If you have to fight, I don't think you can hang the charge one's conspiracy to money launder on the mixing of roughly $86 of licit funds in 2019. I think that's a bit of a stretch, particularly when that $86 wasn't from a conspirator and wasn't essential conduct. I think what the Constitution requires for venue is that essential conduct to the crime charged occur in the district.
Is it your view that essential conduct can only be illegal conduct?
No, but
You
it's,
can advance a conspiracy through a lawful act as well.
yes, you can. But here, when you have count two, what the crux of count two is the representation.
Mhm.
And you have a representation that there's obviously, as this court knows, as we've been going through, there was no response to. And I think that's very problematic, but
I thought we were still on venue for count one and whether there was, you had said that you need an act that's advancing the conspiracy.
well, the indictment, the superseding indictment only mentions Agent Price's mix in count two.
Mhm.
It doesn't mention it for count one. And of course, as the court knows, you have to find venue proper on each count.
Yes.
And what's, again, astonishing to me is we're talking about Agent Price, but in all of this investigation, all of the evidence, when they seize Mr. Sterlingov's 3 laptops, multiple terabytes of hard drives at the airport, his personal notes, a spreadsheet of all of his passwords to his internet accounts, what's astonishing to me is not only is that there's nothing in there that references Bitcoin fog anywhere, there's no direct evidence at all in this case.
You don't have to have direct evidence. I mean, that sounds like a sufficiency argument, not a venue argument.
It is a sufficiency argument because I think that bleeds over in relation to count two. But I think Agent Price's licit mix, a sting where no one was stung, I think that's a really, it's being asked to do a lot more work than it can do. And I think the problem—
I haven't heard you, or to this point, talk about under the venue statute, it says that the prosecution for a conspiracy offense could lie not only where an act in furtherance of the conspiracy took place, but where a completed offense takes place. And I guess just following up on Judge Millett's question, where the government's theory is that the money laundering is happening because cryptocurrency is being mixed, and there might be some mixing of licit funds with illicit funds to wash the money, so to speak. Why isn't a transaction involving licit funds part of the completed offense of money laundering under that theory?
I think because there's no evidence in the record actually of how Bitcoin fog internally worked. And I think if you're going to reach that kind of factual conclusion, you can't do it on this record because the government never found the Bitcoin fog servers. They produced no logs. They produced no internal communications related to Bitcoin fog. If you speculate, which I think this entire case is based on, you can speculate that that's the way that Bitcoin fog operated. But the fact of the record is they don't have any real evidence at all in the record of as how it operated. So if we're going to make some sort of dispositive determination that this was a completed transaction under these terms, you have to fill in facts that aren't in the record. And I think that's the hallmark of this case. If you look at every conclusion in this case—
What facts are you missing? There's descriptions of how it worked for purposes of money laundering. That is, that there was concerted efforts to obscure identities, to make sure transactions were not traceable. And they did that in large part by mixing everything together when the Bitcoins came in so that the Bitcoins themselves could not be traced back to any individual. That's what they don't need to know. Jury doesn't need to look at a server. It doesn't need to read the computer code to understand how something worked. And there was testimony from Mr. Sterlingov or Mr. Akimashti, Amedetu, about the whichever person the jury could find that the two were the same, talking about how this was going to work.
Yes.
If they don't have, I don't understand why they have to find the servers.
Well, if you're going to say that a crime occurred in DC, I think you do need to have some kind of concrete evidence that something actually occurred, or you run into the problem that in internet cases, the venue clause simply will get erased, because if this is the standard for venue in internet cases, then any government agent just acting unilaterally from a keyboard can send a message to any website anywhere in the world that doesn't get a response, and then get hailed in the court and
That's where he
district.
got a response.
He got Bitcoin.
Yeah.
That's the response.
That's a response to that.
He actually got the service.
He got the service, but the service was operating as it should be. He didn't get a response to the message. And again, count two
He got the
is,
service. He got the service. So a business transaction was with a DC presence was completed.
but that doesn't meet the sting requirement of count two's representational money laundering requirement. And I would also be a little hesitant, I think. And I think this is one of the issues with, computer cases. We're in such new territory. This is a matter of, I think, first impression. I think this is the first time this issue has ever been brought up in front of a court. To call that, the receiving of Bitcoin a communication. And I think that's what the difficulty is that I'm having.
Or a transaction. Let me focus you on venue for count 3.
Mm-hmm.
And that's the federal money transmission licensing count. Mm-hmm. So I wonder if you have argued, I know you've challenged venue, as we've just been talking about for counts 1 and 2. And I wonder if you've made a kind of alternative argument that even assuming that the jury and the district court correctly found that Bitcoin Fogg's transaction with Agent Page was money laundering and a money laundering conspiracy occurring partly in DC. So venue is established on counts 1 and 2. Have you argued that Bitcoin Fogg was nonetheless not a money service business required to register with FinCEN?
Yes, at least I like to think I did.
Where in your briefing did you make that argument? I know you've said no requirement to register because no transactions in DC, but have you made any argument that even assuming transactions with DC, maybe a conspiracy occurring in part in DC, nonetheless, no requirement to register?
I think that's made, I want to say in our reply brief and maybe in our opening brief, where we essentially say he wasn't operating a business in DC. I think one of the operative words in the statutes that jump out to me is business. It's not enough simply to have a one-off transaction. I think what happened here, there's 3 mixes, one in 2016. There's the one that we're talking about in count 2, which is the only one where a message was sent. And there's one other one. I mean, if Bitcoin Fog.
Right, did they take their cut?
What?
Bitcoin Fog took its cut out of every transaction, right?
I think that's in the record, but
Yeah, then there's no evidence that didn't happen with respect to Agent Price's transactions. So they got paid. What do you mean?
Well, what's remarkable to me about this?
That's operating like a business.
Well, if it's a business, how come there's no business customers in the record? How come there's no users
Because that's
besides?
the whole point of this scheme. I mean, really, when the whole point of the money laundering scheme, all money laundering schemes, but especially this one, is to hide identities, to ensure there are no records by scrubbing the records on a regular basis. Then it seems a bit rich to come and say, no money laundering conspiracy here, no business here, because there's no business records. That's the whole way this business functioned.
I think
It's a business of obscuring.
I think that when the government manufactures venue in a case like they did here, and you don't have any other evidence of any criminal conduct in the District of Columbia, I think it strains the Constitution to say that venue is proper.
I guess the problem I have with the manufacturing of venue argument is that if you are engaging in criminal conduct and you are willing to do conduct with anybody who contacts you, and you don't know where in the heck that person is contacting you from, if you're doing business with them, then the government isn't manufacturing business venue. You're manufacturing venue by just doing business with whomever, wherever, however. I mean, I don't understand why we should be outraged or concerned about what the government did here. Tell me.
I think the concern is erasing the Constitution's venue clauses in internet cases by allowing unilateral government action without any response, right? Putting aside the jury sufficiency argument, right? Just looking at purely as a legal thing, without any evidence of any response or knowledge on the part of the operator, assuming he's the operator. I think this is very dangerous because it creates universal jurisdiction for the prosecutors.
They did business with this person. They didn't wait to transact business before inquiring, where are you? We don't want to do business with you unless you are in X location.
I think the danger is that you're going to make a rule that mere internet accessibility is going to constitute business for venue purposes.
But let's say you have an internet site that's defrauding people of money and it reaches DC and only one person and it bilks them out of $1 million. No venue in DC?
Well, you would have an actual victim there. Do you have an actual victim in DC and it's not government initiated action?
That's a generic assertion that a government agent posing is just because there's no actual harm, but that's a much broader assertion about the use of government agents in sting operations. I mean, there's all kinds of government agents posing as criminals and getting people who are disposed to deal with them to say they're going to deal with them. And then we day in, day out, we treat that as criminal action. If the person says, yeah, I want to commit the crime with you, let's meet tomorrow. So I'm not sure this is anything restricted to this kind of conspiracy.
I think this case is unique in that in all the other cases I look at like that, right? There's some kind of evidence of knowledge on the part of either the defendant or a co-conspirator. And what's really striking to me in this case, and I think one of the odd things about this case is that there's actually like no corroborating evidence. And yes, circumstantial evidence counts, but when you go and you try to look and find anything that corroborates all these speculations, you're left wanting. And here—
I want to go back for a moment, just because I have an interest in this count 3. You said that you argued that even if there were venue in DC for counts 1 and 2, there isn't for count 3, and you talked about business. And if I'm looking at the blue brief, you say there was no business conduct in DC. It's at page 25 of the blue brief, 25 to 27. And you talk about there's no evidence of any uses in DC besides the government agents mixes, the 3 government mixes in DC. So if we found the government mixes to not be faulty for purposes of venue, do you have a separate argument for count 3? That there was that the FinCEN registration requirement is inapplicable.
I think that stands on that Mr. Sterlingov or Alchemy Shaitan Data or whomever wasn't operating a business in DC. And it's not one of the things that was—
So just for my purposes,
Yes.
and sort of sorting out many issues in this case, if there is venue, because we accept the page transactions as having occurred in DC, if there is venue for counts 1 and 2, you don't have a separate argument that there's still no venue for count 3, as I read your brief.
Outside of the fact that it's not business conduct in the District of Columbia.
That those transactions were not business?
Yes, they don't constitute, because business, at least to me, the common sense of the word is carrying on, business conduct in a given jurisdiction.
Doesn't Page ask for the services of Bitcoin fog to mix his cryptocurrency, and he gets it back. So he's done a business transaction. And I mean, I know you say that's a fake transaction, but I'm trying to say, apart from that defect, the government, it's fake, the government's not a co-conspirator, but apart from those defects, is there any other reason why that you've raised why that FinCEN registration requirement wouldn't be applicable?
Besides what's in our briefs, no, I don't think so. And I think there's, there's the regulatory question that this is an area that there wasn't any guidance on from FinCEN until 2012, 2013, and really doesn't start to get regulatory scrutiny until really about 2016, 2017. And I would just like to point out one thing about the record to the court. You have this government mix in 2019. That's almost 8 years after the acts that they attribute to Mr. Sterlingov in registering the domain name. In that 8-year period, there's no evidence in the record of him operating Bitcoin fog. And I think the problem again with count one's conspiracy charge is if venue is improper on the count one, even if you find it proper on count two, if you just find it proper on count two, you have an $86 money laundering charge. The problem we have with count one is because of the conspiracy charge, then that brings in all the chain analysis reactor evidence. If count one, if venue's not proper for count one, most of this case falls apart because most of the evidence is just co-conspirator statements or chain analysis reactor saying Silk Road in 2013 sent X amount of dollars to Bitcoin fog and got Y back. But I do see I'm over my time, Your Honors.
As long as we have questions for you, we'll give you more time. On count four and venue, if Bitcoin fog was required to file a registration document in DC, why is the undisputed failure to make that registration not an element of the federal failure to register as required by the federal statute 1960 B1B? Why isn't that sufficient to establish venue in DC under the federal statute?
Well, the count four, we're talking about a DC municipal money
I'm
transfer.
sorry, but I'm actually really focusing here on count three and its interaction with the requirement of registration in a state. That one of the ways that one could violate the federal.
Right, in 1960, they state that in the indictment, I think, that the violation of the DC municipal statute. I think if you have the violation of the DC municipal statute, then you are okay on count three. But I think the problem is there's zero evidence that Bitcoin fog was operating in DC. I think what's striking to me about the use of this DC municipal statute against somebody who was in Sweden at all, most of the relevant times, is there's no evidence that Bitcoin fog is actually operating in DC in terms of being a business in DC. I mean, if somehow, what's remarkable to me is that the DC municipal statute is sort of being construed to have a global reach. And I think it's that stretching it so far, you get into due process notice problems with it, because the servers weren't in DC. There's no personnel in DC. There's no communications in DC. So I don't see how you can get a violation of a DC municipal money transmission statute on this record. I think mechanically, what you say logically, assuming 4 to 3, I think you're right on that, right?
Go ahead.
What you're saying mechanically, if there is the money transmission he didn't get the license in DC, and then you can use it as the predicate for 3 in 1960. But I think the problem is that you're really just stretching you have to read the municipal statute in a creative way to say that DC, Bitcoin fog is operating out of DC. I can't get that on a plain common sense reading of the statute. I don't think when it was passed, it was intended that way. I think it's just another thing that they're trying to use as a convenient hook to get venue.
You have more questions? Any questions? All right, thank you. We will give you some time on rebuttal.
Thank you, Your Honor.
May it please the court, Jenny Ellickson for the United States. Sufficient evidence supported the jury's venue findings as to each count. And at the start, I'd like to say this is a sufficiency of the evidence question, and the question is whether the jury could have found by a preponderance of the evidence that venue was established. So I'll start with count 2, the substantive money laundering count. And venue in this case for that count was driven, I think, largely by 18 U.S.C. 1956 I3 that specifically provides that a transfer of funds from one place to another shall constitute a single continuing transaction, and any person who conducts any portion of that transaction may be charged in any district in which the transaction took place. So here, the relevant transaction was the transfer of Bitcoin from Bitcoin fog servers, wherever they were, to Agent Price in Washington, D.C. And to address the representation that Agent Price made 2 days before Bitcoin fog sent those funds back, the jury could reasonably infer that Sterlingov saw that message. I think there's ample evidence that supports the inference that he was the same person as his alter ego who was posting on Bitcoin fog, and that alter ego on Bitcoin fog would, repeatedly touted this customer messaging function that Agent Price used to send the message. Said, and on Bitcoin Talk, said, "We have been using this for all of our communications." I think the jury could reasonably infer that that was correct. I mean, Bitcoin fog is running a large-scale international business. It received over time more than 521,000 deposits of Bitcoin. It needed, in order to keep its customers happy and to keep generating the money, it needed to be responsive. I think you could also, infer from other evidence in the record, that Sterlingov was somebody who had spent, the large majority of his time online, and Bitcoin fog was, clearly a central focus of his life. And so the idea that this message would have gone 2 days unread, I think, is the jury could reject that inference and find the opposite. And then with respect to the conspiracy count, I think the Agent Price's transaction is, and the funds sent back to Agent Price were acts in furtherance of the conspiracy, as were the status updates that Bitcoin fog transmitted back to Agent Price, kind of assuring him that things were going well, that payment was going through. These are things that Bitcoin fog communicates to people to, again, raise confidence in the service. And, when Bitcoin fog sent that transaction, Sterlingov may not have known that it was going to DC, but again, this is a large scale international operation. It was benefiting from the fact that the internet allows you to engage in conduct in places that are geographically far from where you are personally physically located. And
Ellickson, I have a question again about counts 3 and 4.
yes.
So those counts are different because it's one thing to say you're operating an online business with global scope, and if you commit a crime through an online transaction, that crime is going to be subject to prosecution where element of it occurs, where conduct, necessary to show it, or conduct that supports it occurs. That seems like a different point from the point that if you operate a money transmission business from Sweden and you do any transaction with someone in DC or anywhere in the United States, that one transaction is, even if the transaction itself completely lawful, if you haven't registered with FinCEN before you do that, you're criminally liable under count 3. If you haven't registered with the state authorities under the DC code, you're criminally liable for having done that one transaction. Is that your theory?
Well, so I do think that the jury could reasonably infer that Sterlingov and Bitcoin Fog were engaging in business and operating in DC. I think it wasn't just the agent price transactions. Also, there was another undercover FBI analyst who conducted undercover transactions in 2016 as well.
But you're not arguing that there's a 2 transaction threshold. I mean, is there a difference between engaging in a transaction that gives rise itself to criminal liability and conducting one transaction as the basis for, under the statute, conducting an unlicensed money transmitting business in DC? Like, when you think of, just in sort of common sense terms, when you think of needing to get a business license to operate in a place, it's a little bit more like that's where you're doing your business. That's where your business is cited, not where some of the transactions might touch, but where your business is cited. And, there's some language in the DC code and in the federal statute that supports that. No person shall engage in the business of money transmission in DC, not do a money transmission transaction.
Yeah, I understand what Your Honor is saying, but I don't think that the statutes require kind of a physical presence requirement.
But not physical presence, even like a substantial, nerve center or outpost or something more than just serving a customer who lives there and who reaches out. I mean, it's interesting that money transmission in the DC code refers to receiving money for transmission or transmitting money within the United States. In other words, the defendant would have to have received money for transmission within the United States, have to have been in the United States when the business received money, or transmitting money within the United States. And the business did neither of those things, didn't transmit money within the United States, transmitted money from Sweden to the United States. So there's just a sense of like some kind of virtual or actual presence. So, and I mean, if a US business is sending, doing a money transaction with Azerbaijan, and Azerbaijan said, if you're not registered, you have a $1 million criminal penalty. Really? That's the position of the United States, that's completely fine, consistent with due process, consistent with the venue clause of the Constitution?
Well, I think that the jury could here infer that Bitcoin Fog was that it wasn't just these 2 transactions. Maybe, DC aside, if we're looking at the United States with the FinCEN requirement, if you have an international business that is doing 521,000 deposits and 693,000 withdrawals, he is posting in English on Bitcoin Talk. He, I think in his exploit post, which he made under his own name, he refers to the fact that you can use Tor to evade even U.S. law enforcement, indicating that he understands that his service may be especially attractive to people in the United States. But I'd also like to just push back on the idea that count 3 depends on this court finding that he had a registration obligation in the United States and in D.C. I will say I don't understand him to have contested that in his briefs. But even if this court decides to reach that issue, under 18 U.S.C. 1960 B1C, that does not rest on kind of a formal registration requirement. That instead says that a money transmitting business is unlicensed if it otherwise involves the transportation or transmission of funds that are known to the defendant to have been derived from a criminal offense.
Right. So there is a piece in the federal statute that basically says there's no such thing as a licensed criminal transaction. And so if you're engaged in a criminal transaction with the United States, then under FinCEN, you're unlicensed. I get that. You don't have that theory for the DC requirement.
For the DC requirement, that's right. The DC requirement is a registration license requirement. That's correct.
And a DC requirement depends on engaging in the business of money transmission, which is defined as receiving money or transmitting money, receiving money for transmission or transmitting money, and doing that activity in the United States.
Yes, I do think as a practical matter that it is in fact incumbent on businesses that are engaging in money transmitting business throughout the United States, that they in fact register in the states in which they're operating. I suspect that PayPal has registered, basically everywhere in the United States that they would be required.
And also everywhere in the world.
I don't know, about that. I'm certainly not an expert in international law, but I think that it is something that, this is somebody who's running an internet business and is reaching into the United States and is doing business with United States customers. I think they are subjecting themselves to US law, to state law, to DC law.
So is that right? If I'm running a bank in San Antonio, Texas, and some of my customers use Zelle or Zelly, I never actually know how that's supposed to be pronounced, to transfer money, and some of the customers are in DC, then my San Antonio-based bank has to file for a DC money transmission license before I can deal with that Zelle transaction?
Yeah. Again, I don't want to kind of give business advice to the business in San Antonio, but I do think here the jury found on instruction.
So we don't know what the pattern of conduct is with respect to banks within the United States or money transmission businesses in the United States, whether they have every state and local license that they could possibly have.
I understand informally. This is, I have looked into this a little bit informally, and I understand that the big money transmitting, if you're engaged in money transmitting, it is common to, seek registrations everywhere, and that some businesses find some jurisdictions sufficiently burdensome that they, in fact, avoid doing business with customers in those jurisdictions because they don't want to have to comply. And that is something that obviously Bitcoin Fog, if Bitcoin Fog had any aversion to doing business in the United States or doing business in DC, they could have asked the very kinds of questions of their customers that legitimate businesses, Bitcoin businesses do to try to find out more about them and where they're operating. If they said, and this again goes to the idea, I think that there's no manufactured venue here because Bitcoin Fog was open to all comers, even if manufactured venue is a viable theory. And I would like to, I know this court, we've moved on from counts 1 and 2, but with respect to the role of the agent in all of this, I think this court's decision in United States versus Sitzman from 2018 is quite analogous to what happened here with the role of the agent being the initiator of a wire from Florida to DC, where the agent asked the co-conspirator of the defendant to send the wire. It wasn't an agent. It was an agent asked a cooperator in DC to ask the wire be sent to DC, and the co-conspirator did. That seems analogous to the situation here. But I do want to make sure that I've answered the court's questions with respect to counts 3 and 4 also. So if the court has further questions about that or about the other issues in the case, I'm happy to address them.
I wanted to ask you briefly about the Mazars expert testimony.
Yes.
You said it was likely, when in comparing the IP addresses, that it was likely the same user using both accounts based on the overlap. What was the reliable basis for that conclusion that it was likely? I didn't see testimony about how rare the number of overlaps is, how ordinary, how many overlaps are there, or when there's ordinary folks doing it, they're still separate, but they're on the same VPN or Wi-Fi or whatever. What was the basis in the record for that? telling the jury it was likely that these two were the same person?
Well, I think I think there were 4 times where she gave testimony that was similar to that. And at least 1 or 2 of the times she did provide some information for why some additional basis for explaining. I think once she said when it was only a minute apart, she said, you know, the fact that these are only a minute apart and they're both into cryptocurrency exchanges, that seems to me that it's likely. And then another time it was when it was an IP address that logged into the Shorement Liberty Reserve account, and then the Sterlingov's Liberty Reserve, and then the Shorement account again. And she said that sandwiching. So those were some of the things that she was pointing to, these additional factors to suggest that it was likely.
Likely assumes some sort of baseline understanding of what are the chances that could happen by chance.
Mm-hmm.
It just happens in the universe. And so likely is a comparative term. And normally when you hear that testimony from an expert, there's some baseline as to, you know, ordinarily you don't see this type of overlap. You know, it's one in 1,000 times you can have this kind of overlap and it's not the same person. But there's nothing like that here. There's just no framework for the likely conclusion. She sort of spells out, here's some facts I saw.
Mm-hmm.
And so they must be likely because I saw these facts.
Mm-hmm.
And that seems to me the type of thing that Taxpayer might have very much been, is that Taxpayer? I might have that wrong too, but Taxpayer might have been designed to prevent, is someone coming in and saying, I saw A, B, C, D, and E. And in my view, that's a likely thing without any framework for reference.
I think that when she talked about how quickly IP addresses cycled, IP addresses of different types cycle, and I think the fact that the accounts had this connection, I think this is something that the district court could reasonably conclude would go more to weight than admissibility. And certainly Sterlingov cross-examined her extensily about the fact that multiple.
There definitely was cross-examination on that, but the whole point of the Taxpayer gatekeeping function is that we don't let everything in and let it all be argued about weight, that there has to be some at least reliable basis for the conclusions, something reliable enough that we can tell the jury this expert is an expert and is giving you information based on expertise. And I'm still struggling to understand. And the most important part is not just, I saw this happen, this happened, this happened, this happened. That's like witness testimony. The expertise was in her conclusion then. It was likely that they were the same person. And so I'm going to repeat myself here,
Yes.
but I don't know how we know it was likely or not. She gave no information. And I get there was cross-examination on that. But should it have been let in the door anyhow? That's the point of the Taxpayer process.
Yes, and I guess what I can point you to is in her Taxpayer testimony when she talks about the different types of IP addresses and how quickly they cycle. But I agree with you, you know, that if you know the record is what it is. If this court has concerns about the reliability of that, you know, small piece of her testimony, I think it was only, you know, she had 4 fairly quick opinions. Most of her testimony, even on the IP addresses, was just describing what the data said.
No, but that's my point, is that, you know, the expertise. I mean, anyone could sort of say, that's like a fact witness. Here's these transactions I'm seeing. The expertise is in the conclusion, the culling of the information into a conclusion. And this was your evidence on identity.
Oh, I disagree with that. I think there was substantially more evidence on identity than this. I'm happy to kind
Substantial?
of. Oh, yes. Oh,
Okay,
yes. I'm happy to walk through. So before Ms. Arz even testified, the jury had already heard about the layering transactions that went from Sterlingov's own financial accounts to purchase the domain name associated with Bitcoin Fog. That tracing was done, came in both through Agent Leo Ravinsky's testimony and through Luke Scholl's testimony. The fact that he made the first deposit into Bitcoin Fog before Bitcoin Fog was even announced, and that he did that from his personal account. That was also evidence, had nothing to do with the IP addresses. He made additional early deposits into Bitcoin Bitcoin fog through these layering transactions. Also, and this doesn't relate to any IP address expertise, on the same day that the jury could infer that he purchased this domain name, an IP address in Gothenburg, Sweden, where he lived, access to the Shoreline Liberty Reserve account. That's just a fact. That's not opinion testimony. It is something that Mazars addressed in her testimony, but it's just saying what the IP address record said. There's also the fact that he, through his personal Bitcoin Talk account, engaged in communications with the owner of Blind Bitcoin about a month before he actually launched Bitcoin Fog about wanting to acquire Blind Bitcoin. And then later his alter ego on Bitcoin Fog references how he'd been following the Blind Bitcoin project. He also had his exploit messages under his personal account where he was encouraging the use of Silk Road, touting Tor for privacy. He told a friend 5 months after Bitcoin Fog launched that he gave up a side project because some other things were yielding more cash. And then there's all of the financial information about how he had $1.8 million worth of Bitcoin that came into 40 different financial accounts, that he had $500,000 in Bitcoin on his phone, including much of that in an account called Straight Outta Mint. That account in August 2020 received a $280,000 Bitcoin deposit directly from Bitcoin Fog. That's at the appendix 39, 37 to 38. So none of that evidence had anything to do with the Mazars IP address opinions. I mean, even the fact that there were some IP addresses that were common IP addresses for these layering transactions, it's just a fact that those were, that 1 minute one logged into one account and then the next minute it logged into another account in the chain. And a jury who sees that evidence is going to draw the common sense inference that, given all of these facts, that is further evidence that it was Sterlingov controlling both accounts. Isn't
it the case that all of that factual evidence would be clearly admissible, and really what Mazars was doing was just kind of connecting dots between clearly admissible factual evidence?
Yes, I think there's no dispute that the underlying IP address log information, it would be admissible either way. That wasn't opinion testimony. She was just basically putting before the jury, he logged into this account and then he logged into this next account in the transaction, or the same IP address logged in 1 minute later. Even if this court has concerns about the reliability of that kind of very small sliver of what she said, I think, the jury probably would have drawn the same inference based on common sense and, what people generally know about IP addresses.
She just educated them about what it all meant, that it was likely.
Yes.
That was part of maybe the pinnacle of her function.
Yes, no, but Sterlingov on cross-examination, he pointed out all of the reasons why they should, they could take a different view of the evidence, and why in his view they should take his view of the evidence, and that these could be two completely unrelated people logging in. So I think that the district court was within its broad discretion in determining that her testimony was reliable. But even if this court
How did the district court make that determination in this case?
He heard her Daubert testimony, and he didn't specifically announce, at any, he didn't make a specific detailed ruling
anywhere.
But the fact that he allowed her to testify, and I believe he qualified her as an expert on these things, and so I think that indicates.
Where did he qualify her as an expert?
I think I can't remember if it was the beginning of her trial testimony, but I think she was admitted. He admitted her as an
no explanation for his conclusions as to reliability, expertise.
Yes, no, that's right. He didn't.
There's also no objection at that point.
Yes, there was no objection. And I think that honestly, Mazars was sort of she was the focus of the expert back and forth was really on the reactor evidence and the blockchain analysis experts. And that was really where, the parties and the court were focusing their attention. And I think Mazars was, it was not something that was a focus of.
There's definitely objection. That's the whole reason there was a Daubert hearing. She was put into the Daubert hearing. So they definitely objected to her expertise.
Yes, but I don't take them even in their brief before this court, their briefing before this court, to be raising the concern that Your Honor has raised about the opinion piece of it, the likely testimony that what I understand their objection to be is her use of these overlap windows, which were really just something she used to filter the data. And I don't understand them to have raised this different objection that Your Honor has raised. So I think, if the court did want to go there, I think it would be a plain error thing, and perhaps is an issue that the court is noticing on its own. I see that I'm over time. I'm happy to answer more questions from the court if you have further questions, but.
Why wouldn't the government, when it's introducing evidence about not just child pornography, extremely abusive child pornography? There's no good child pornography, but there's extremely abusive. Why would you even have to say the words child pornography? Why wouldn't you just say, stipulate this is violated in the federal law? This is a violation of federal law.
Well, I think there was evidence that one of the things that we needed to potentially show is that Sterlingov knew or was willfully blind to the fact that Bitcoin fraud could be engaging in this kind of conduct.
But the indictment is all about drug money. I mean, the indictment isn't about money laundering for violations of federal law generically, or even different categories of violations of federal law. This is all about a drug money conspiracy. And then you come in at the end and you sort of say, well, you've got this explosive information here about a teeny tiny transaction it was only money going out. It wasn't even money coming in, that involved a federal offense that's not charged in the indictment.
Well,
But it's absolutely toxic and nuclear when raised before a jury.
So I actually disagree with the idea that this wasn't covered by the indictment. This was offense conduct for count 3 going to the 1960 B1C count, because that count required the government to prove that he was engaging in activity that used to promote or support unlawful activity. And it didn't require specification in the indictment about what type of unlawful activity. So the government could prove that.
The government's arguments tie it to the jury solely for count 3. Or they argue it generically.
No, because I think it was also relevant to other counts. And I can walk through the probative value for the other counts as well. But I also want to push back on the idea that there was something,
Why
very inflammatory.
Of course, everybody knows there is. That's why there was any limitation at all in the first place. But you don't even need to name it as child pornography. We all know why the government wants to do that, but it seems to be the very reason that it shouldn't be done in front of a jury.
Well, child pornography was
horrible stuff.
It was actually already in the case before the welcome to video evidence came in.
There was a loose reference at one point way back that money could come in. But in fact, this money didn't come in. It only went out.
No, but he did.
Bitcoin only.
Yeah. In his exploit post, he wrote an exploit post not too long after Bitcoin launched, where he said that, you can use Tor to purchase drugs and unfortunately child pornography. That indicated that was already in the case.
That was describing Tor.
Yes, but it still, shows that he had an awareness that the dark net was being used.
Well, I have an awareness of that. Everybody has an awareness of that. That's why there's a reason those transactions are done on the dark net. But that seems to me not much of any justification at all for the decision to. It's not whether the evidence could come in for point 3. The question is why the government wanted to reference it as child pornography.
I think it as a factual matter, that is one of the types of illegal conduct that he was furthering. But I think
all you needed to say was there was a stipulation. All you needed to say was a violation of another federal law.
I think that the connection
made the connection. It would have satisfied count 3. You could have argued, see, here's another instance. The timing of it is more recent.
I think the connection to the exploit post meant that the specific type of criminal conduct was relevant, but also the fact that the reference to child pornography kind of stripped of any details, I think really, made the evidence kind of not that inflammatory. And certainly Sterlingov
It was
repeatedly.
argued by the government to the jury. It
is part of this.
It was pounded.
It's part of the story of what Bitcoin Fog was doing. And I think it was also, when Sterlingov certainly in his cross-examination and in his arguments, he did underscore the fact that this was a small amount of money and that it only came out, that I think the jury would have weighed that against the fact that Bitcoin Fog had taken in tens of millions of dollars from drug dealers. I think, some jurors might be much more bothered by the drug conduct than by this small amount of money going out to a child pornography website. And the fact that because of the parties' stipulation and the exhibits could not be more anodyne. There's nothing inflammatory at all about the exhibits. And, I'm not even sure if there was an objection the first time that the fact of child pornography was mentioned in connection with Welcome to Video, or if it was just that the objection came in when it was going to be the exhibits and that the focus was really on the exhibits. So I'm not sure that it was the idea that child pornography kind of writ large was the problem. I think that the objections that the defendant was focusing on at trial were really that there was something about the titles and descriptions on these spreadsheets that created a problem. And that was what the district court focused on, and the government, agreed to redact that material. It wasn't the idea that kind of any mention of child pornography.
One more question. Sorry,
Mhm.
do you have any questions? No. I just want to circle back one more time to venue. So the theory is that Agent Price's transactions show continuation of the conspiracy. Given that all of the conspirators listed in the Bill of Particulars had ceased to exist outside the limitations period, with whom, what is the evidence in the record as to with whom Mr. Sterlingov was conspiring at that time?
I think that so it is true that a lot of the evidence was from before July 2017, just because of the success that law enforcement had in shutting down some of these dark markets. But the jury could infer that basically when one darknet market goes down, another one pops up in its place. That's what happened with Silk Road and Silk Road 2.0. And in fact, there was at least one of the distributors on Silk Road who appeared to have migrated to Silk Road.
That was all before the jury?
Yes, that was in front of the jury. And so I think that
That's what I was trying to find. How much evidence was there that replacements, either smaller ones grew or new ones came on?
I think that
before the jury.
Yeah, so the jury did hear the evidence about the specific Silk Road users, and then the shutdown of Silk Road, and then the evidence of the Silk Road 2.0 users. And I believe there was at least one person who appeared to be the same. They had the same username, something like that. And so the jury could infer that basically the individual vendors on these darknet markets, they're not going away just because a particular darknet market shuts down. They're going to find another way to distribute their drugs on the darknet. And they're going to continue to use Bitcoin Fog because Bitcoin Fog is an effective way to hide their drug money.
And just forgive my ignorance, was the Silk Road only drugs, or is it just general criminality?
I think it was known the most for drugs, but they had all sorts of.
Because you have to show a continuing drug conspiracy.
Yes, no, it was
just other bad acts.
It was principally drugs, but it was they also had, I think, other
the
types of.
Continuation was based on the fact that there was what you called a Silk Road 2.0 doing transactions on Bitcoin Fog.
Yes, and so these were users whose funds were being traced into Bitcoin Fog, and the government presented evidence about what they were selling on Silk Road and Silk Road 2.0, and again, all of that evidence predates the 2017 date that is at issue for the statute of limitations. But again, I think that the jury heard testimony that the darknet is a place where people are selling illegal drugs, and I think the jury could reasonably infer. Did
you identify a new conspirator within the statute that was within the statute of limitations period?
I'm not sure. I can't think of one, but I don't think that was required, because a conspiracy charge can be with people known and unknown to the grand jury, and so the conspiracy can continue.
Entirely unknown. There were no more knowns at this point.
Well, I think there certainly was the conspiracy. And again, also, I just to bracket this, that none of this is a concern that I understand Sterlingov to have raised in his.
They definitely talked about how they definitely raised this issue. I mean, people tell me if I'm wrong about how all the conspirators that are named, and he did it again now this morning. All the conspirators identified were out of business before outside the statute of limitations period. And so the government's theory is that the conspiracy that's within the statute of limitations, the conspiracy can be lawfully charged is entirely with unknown conspirators.
I think that it's, I'm not sure that there, I can't think of anybody from the bill of particulars where the evidence came in that it was after.
And there was no evidence of replacements, actually. Again, you talked about replacements, but not within the statute of limitations. And you didn't talk about any replacements that would have been putting money into that could be.
I mean, I think what we know is that Sterlingov was continuing to run the money laundering.
He was continuing to make Bitcoin Fog was continuing to still make a lot of money. We know that, but this is a conspiracy. And so is there authority for having the conspiracy be just with unknown?
Well, I think
unidentified.
I would also say that I don't think that there is any evidence that, and I don't think Sterlingov has attempted to present any evidence that any of those conspirators, where the evidence is from before 2017, that any of them withdrew from the conspiracy. So in order to show that somebody left a conspiracy, you have to show some kind of withdrawal. And
if they just don't exist, I mean, these are businesses. These aren't human beings. What if they just don't exist?
Well, but some of them were, the individual vendors who were happening to use certain darknet markets as the platform for selling drugs. But that doesn't mean that they didn't then migrate to.
So as for the government's proof here.
Yes.
On statute of limitations, you cannot think of any record evidence within the statute of limitations period of an identified conspirator.
For the drug conspiracy, I mean,
for the drugs, because that's what's charged in the indictment.
I think that one thing that I think this obviously Agent Price is not a conspirator, but I think Bitcoin Fog's handling, continued willingness to launder that transaction, believing him to be kind of potentially a new conspirator.
That's just not a conspirator, though.
No, he's not. He's not a conspirator, but I think it's again kind of information that allows the jury to draw this inference. And certainly, I think the fact that Bitcoin Fog was still making so much money when it had gotten so much money from these darknet markets before, I think, is an indicia. If its business, if its profits, kind of still remained fairly high, I think that's an indication that it's operating in the same way that it always was with these customers coming in.
Are there cases, because some of this I think is sort of a product of the more modern era of crime commission on the internet. Are there cases where all of the known conspirators are outside the limitations period and no others are identified? It's all unknown after that. Anything that says that's okay that you're aware of?
I think that there certainly are conspiracy prosecutions where the government's never able to identify who in the real world the conspirators are, because they have used the internet to kind of pull back, for child pornography conspiracies. Often a defendant will be conspiring with a lot of people on the internet, none of whom can be identified because they've hidden who they are in various ways. So I think that would be probably the best analogy that I can draw.
Thank you very much. Mr. Eklund will give you the 3 minutes you asked for.
Everyone in this courtroom that is using the internet right now is probably on the same IP address. That obviously doesn't make us the same people. And Judge Millett, I think you made a very good point about computer scientist Mazarin, as she was introduced to the jury as a computer scientist, has no basis for making any kind of probabilistic determination as to whether or not Mr. Sterlingov was more or less likely to be using these email addresses that they attributed to him solely through computer scientist Mazarin's novel IP overlap analysis. She admits that thousands of people can be using the same IP address.
Your argument in your brief to us is not about this likely explanation that she gave. You argue that it's the unreliability, that she was relying on information from, I think, the IRS. Yes, IRS data. And then you argue a lot about the UTC, coding it in UTC time, whether that was reliable. But I don't recall you arguing to us that this was impermissibly admitted expert testimony because of her categorization of the probabilistic categorization that she provided to the jury, I was curious about that.
Well, so we did cross her on her error rate, and she said, I can't tell you my error rate. I can't cite any scientific peer-reviewed paper that this is accurate. This is the first time that I've done that. I think it follows from that, the fact that you can't calculate.
It doesn't follow from that, what you cross-examined a witness on at trial, that you have raised a legal argument about the basis for her probabilistic prediction or characterization in your Court of Appeals brief.
I would submit to the court I have, because you can't calculate any kind of probability if you don't know the error rate. And I think that goes to its unreliability. And I think that's a core issue in this case across the Dauber, however you say it.
You can know error rate. That's the whole reason. That's how you decide what the probability is. And that's what you were cross-examining her on. But I'm talking about the sort of comparative evidence that you would want to know what's likely or not.
The problem, I think, with her ad hoc methodology is that there is no way looking at it to make that determination. That's what I understood you to be getting at. That to me seems plain from its face. Right. I don't know what more to say beyond what we said. It's unscientific. It's, what we said. But I would like to address something with respond to what the government said. I think computer scientist Mazarin's expert testimony, overlap analysis is central to the identification. That trace that they referred to in 2011, where Mr. Sterlingov allegedly purchases the domain name for the ClearNet website, that's entirely dependent on attributing control of accounts to Mr. Sterlingov based on computer scientist Mazarin's IP overlap analysis. I think it's the second Mt. Gox account, and then the third big account in that chain. It's very, very convoluted. This notion that there's an independent evidence IDing Mr. Sterlingov outside of Ms. Mazarin's IP overlap analysis, I dispute. I don't see it anywhere. I think their case in terms of the identification turns entirely on her novel IP overlap analysis. I don't see how you get any identification of Mr. Sterlingov as Akamisheta Amideta, as the person all the way at the end of this purchase of a domain name registration in Sweden in 2011 without that analysis. And I think the fact that the gatekeeping function of the district court didn't keep her out, and she was put in front of the court as a computer scientist with all the authority of the FBI in this very, very confusing case that's almost entirely built on expert testimony, no eyewitnesses, no victims, no corroborating evidence anywhere. The government never bothered to get Mr. Sterlingov's computer from his apartment in Sweden.
Okay, I think that's not really a legal argument before us. Do my colleagues have any more questions? No. Okay.
Thank you, Your Honor.
Thank you very much. The case is submitted.
Case number 26-5006, Center for Taxpayer Rights et al. Versus Internal Revenue Service et al. Appellants. Mr. Christensen for the appellants, and Ms. Gilmer for the applicants.
Good morning. Thank you. Jacob Christensen for the federal appellants, and I would like to reserve 2 minutes for rebuttal. May it please the court. This court recently held in Centro that IRS is obligated to disclose taxpayer address information to ICE upon receipt of a valid request. And this court upheld IRS's policy of sharing address information with ICE, which is reflected in a memorandum of understanding between those agencies, holding that the address sharing policy was unreviewable under the Administrative Procedures Act. Yet the district court in this case has wrongly enjoined IRS from implementing its address sharing policy based on the court's conclusion that IRS has adopted some other address sharing policy that allegedly exists separate and apart from the memorandum of understanding at issue in Centro. No such separate policy exists, and the district court lacked authority to enter the preliminary injunction here because plaintiffs lack Article 3 standing, because they have not challenged final agency action under the APA, and as this court already held in Centro with respect to the memorandum of understanding, and because plaintiffs have not otherwise demonstrated that an injunction is warranted. And if I may,
you said that the other side can address and that this court can consider the Romo Declaration as part of this appeal. Right? If plaintiffs wish to discuss the Romo Declaration in their appellate brief, they are free to do so. I assume that means that we're allowed to read it.
Your Honor, I think the court is allowed to read it. I don't think that it properly figures into this or should figure into the court's decision because it was.
Well, that's a different, I just want to understand here. You said they're free to brief it, which means we're free to read it. Otherwise, I would expect the government to say otherwise. No argument that we couldn't do that. We could take judicial notice of it because it was filed with us in the Ocentro case. It's filed with the district court in this case.
I agree with that, Your Honor, but it was not part of the record before the district court at the time the injunction was issued. So technically, it's not on the record on review of the preliminary injunction at issue.
So we can supplement the record under FRAP 10E2. And given that the government has had no objection to its use in this proceeding, its consideration by us. Is that, so I mean, there is also, as you know, a question about an indicative ruling, whether do we have to remand for the district court to make it part of the record, or can we just make it part of the record ourselves under 10E2?
The government wouldn't have an objection to making it part of the record, Your Honor. We don't think that the Romo Declaration changes the outcome in this case, as we've explained in our opposition to the remand and in our briefing. The Romo Declarations reflects an error in the way the IRS's address sharing policy was implemented.
It essentially describes the DHS ICE data exchange program, which is in the record, starts at JA 462. Written document. It's an exchange process established presumably to implement the MOU. So this is sort of, we had a facial challenge to the MOU in Ocentro. And now we got, as applied, what is the government doing? And that's what the data exchange program tells us. And that tells us you are not complying with the law. You are not complying with the requirements of the statute. Romo Declaration says that's right. The government says, well, we weren't doing that, but we've got a document here.
Your Honor,
Government explaining, implementing the MOU.
if I may,
I'm just going to finish the setup here.
Mhm.
Clearly in violation of the statutory requirements. And happens to be, I think the district court used other words, but exactly what the district court was saying is the problem here. This is the as-applied problem, and the problem is in writing and documented.
if I may, Your Honor, that's right. What this was an error in the implementation of the IRS's address sharing policy. The plaintiffs in this case do not challenge the August 2025 disclosure by IRS. For reasons of their own, they have not challenged the implementation in August 2025. Their argument in this case is that IRS has adopted some address sharing policy apart from the memorandum of understanding
Yes,
that they argue is
that's
unlawful.
what this is.
Well, what this document
this
is,
is.
this data exchange overview reflects how IRS implemented its address sharing policy. That's what it
As-applied
is.
aspect of this, yes. But
But that's not what they're challenging.
This isn't
They're not
just about
challenging the
labels.
way,
I'm sorry.
pardon me.
No. I mean, they'll tell me if this is not, I mean, this is documentation of the very, we call it a policy, a program, the church challenge you. This is exhibit A. This is it. Here it is. Don't tell us this policy doesn't exist. Here it is.
I would disagree, Your Honor,
Okay.
that the policy is
Tell me if they're not
reflected,
challenging.
the policy is reflected in the memorandum of understanding, which this court
No.
recognized
You
in,
just said there has to be as applied and that I mean, can we agree that this data exchange program does not comply with 6103?
I would
I do.
agree that the implementation in August 2025.
No, that's not the question I asked you. I'm asking
I'd
you.
like to hear the answer. The implementation in August, which is not challenged here,
Yes.
was in violation. I mean, the Romo Declaration says there were disclosures made where ICE had not submitted addresses.
Yes, with respect to a small percentage of the individuals whose
So that-
information was
so that-
disclosed.
Implementation, and your point is, yes, concededly unlawful,
Right,
but not challenged. Okay, go ahead.
right.
Okay.
But again,
Do you agree-
plaintiffs
do
aren't
you agree-
challenging that implementation.
Do you agree this is unlawful?
I agree that the way that it was implemented did not comply with the statute
Okay, let's
because,
try this. Let's try
but the policy,
Let's try
IRS's
this.
policy,
Sorry, let's try this in
Mhm.
smaller steps, okay? Did this data exchange program that's in the record here, was this in place in August? When the
Yes.
Yes.
it was.
And this is in fact, there were lots of emails in the record back and forth. This is how we're going to make this disclosure that occurred in August, correct?
This is a way that they plan to
There's
implement,
lots of emails in the record.
the policy
Yes.
reflected in the
Back and
memorandum
forth
of
between
understanding.
IRS and DHS and this, and then this is the product of it. And there was lots of discussion about this.
I don't know that there was discussion about this specific overview document in the appendix at page 462.
This is the DHS ICE data exchange overview.
Yeah, I think this was internally created
IRS.
by IRS
Yes.
to implement its policy that's reflected in the MOU. And again,
No. This is the IRS policy that was used in August. We don't know if was used otherwise, but resulted in the turning over of information in August.
it was the way that the policy was
And this thing is
implemented. It was the
not-
process for implementing the policy.
And
But the
on
pol-
its face, step after step after step, does not comply with 6103. So the policy that was adopted to implement the MOU does not in fact implement the MOU. Unless we got it all wrong in Ocentro on thinking the MOU facially complied with the statute.
You know, the IRS's policy is reflected in the MOU was to require a name and address.
Okay, I think the
It was
policy
in-
can be
it was-
reflected in, that may have been their policy at the time they were arguing that case to us. But that case was still pending here when the August release occurred. But more importantly, that case was still pending here when this data exchange overview was adopted by IRS.
Okay. Again,
We were told about this.
I agree that in implementing its policy, IRS made a mistake.
No,
But the emails
I made a
back.
mistake. This is, you wanted to say there is no policy. I'm looking at this program right here.
Well, if you look at the entire record, you'll see emails back and forth between Treasury and IRS where Treasury officials insisted adamantly that any ICE request must include a name and address. And that's consistent with what was in the memorandum of understanding.
An address, what this tells us is address just means fill in the zip code box. And by the way, it doesn't have to be a real zip code. Just put 5 numbers in the zip code box. So now this is the rubber meets the road document. This is the implementation. This is the as applied challenge.
Again, but Your Honor, they are not challenging the as applied disclosure in August 2025. Their argument is that
I understand it is how you are implementing the MOU. And that's what the district court was very troubled by, is what you're actually doing in practice. And it's in writing.
Well, I would push back on that. IRS's policy has never been to respond to requests that did not include an address. The intent has always been to require the address.
We don't have mind readers as part of this APA challenge here. So what we have is IRS saying in this document, all right, we're going to check and make sure. Sorry, did you need to get your
If I may.
appendix? Yeah, sorry. Okay. Sorry if I've made you dry mouth.
No, it's all right.
Is that for the address, all we need is something in the zip code box. And it just has to be 5 numbers.
So Your Honor, it's an error.
And presumably you're going to have and I forget, are we calling it the EIN or the TIN or whatever we're calling it? But if you have that number, then we'll just go ahead and match it with that.
It's an error in implementation, but in order to challenge this as a policy.
Or is it the implementation?
It's an error in the way the policy was implemented. In order to challenge a policy, there must be, there's got to be a rule under the APA, and a rule is defined as an agency statement that is designed to implement or interpret or prescribe the policy or the law.
Yes, and that's exactly what this is doing. Here's how we are going to implement. I mean, this is step by step one. Step 1, IRS receives input file from DHS. Step 2, pre-processing tasks. Make sure certain things are filled in, one of which doesn't have to be an address, as long as there's 5 numbers. Give me any 5 random numbers in the zip code box.
Well, so that
Step 3, find the last known address process. Step 4, as either SSN lookup, or we're doing the SSN here being the TIN or EIN lookup lot. You got that and something in the zip code box. We're going to match it. We're going to give it to you. That doesn't comply with 6103. Step 3B, if you're only doing on name and address. 3C. I mean, these are the steps by steps. This is the implementation. This is how. And if you say this is an error because it's doing it unlawfully, we're agreed. But this is the policy. This is the practice. This is the program for implementing the MOU.
Well, and with respect, Your Honor, if any such policy would be directly contrary to the policy that has been adopted explicitly and signed by the heads of the agencies reflected in the memorandum of understanding. So I disagree that there's some policy
Is this a false document?
This is a document that implements the policy imperfectly. I acknowledge
As in
that.
unlawfully.
With respect to the extent it doesn't require an address, it's an error in implementing the policy.
Can I try? Your position in the Centro case, which was successful, was that the MOU wasn't a policy. Right?
Was not, did you say?
Was not a policy. Now, it wasn't final agency action.
Well, it was a policy, unbinding policy statement.
but it wasn't final agency action. That's how you won, or one of the grounds for how you won. Now you're saying in this case that this data exchange at Appendix 462, that's not final agency action either,
Correct.
because it can't override the memorandum of understanding? Is that why it's not final agency action? I just want to make sure I understand your theory for why this isn't final agency action.
This document would not be final agency action for the same reason that the memorandum of understanding itself was not final agency action. It's because it's a non-binding policy statement, which has no actual legal effect or legal consequences on anyone. It simply reflects what IRS's own views of what the law allows it to do in providing address information to ICE. As this court explained in Centro, a policy statement that simply reflects the agency's views of what it is allowed to do under the law does not have binding legal effect on anybody. And in this case, that's all the more important because the information that's being shared is address information, which plaintiffs and their members, or the members of the plaintiffs in this case, were already required under federal law to provide to DHS. So even if this address sharing policy, well, that means that the address sharing policy
where is the so you're not disputing that an action by an official to disclose addresses is a final agency action, right?
That would be a more difficult question, but plaintiffs have not challenged.
Just answer the question.
We've not raised that argument, but they have also not challenged the actual implementation or the actual disclosure.
I'd like you to answer the question. I don't care whether you've raised the argument. When an official says, we have a request, give them this information in response to the request, is that a final agency action?
In general, I would agree that that would be, Your Honor. In this context, I would disagree. And the reason is there's no binding effect. There's no legal consequences from that action because the address information is already required under federal law to be provided. The aliens are already required to provide that information to DHS.
So there's really two arguments in the MOU context where one, it wasn't saying anything different from what the law required. And I mean, it was, and you say it was only guidance. I mean, it was binding, but it wasn't doing anything new binding.
Well, this court said that it was a non-binding, non-final policy statement as opposed to a binding rule. It was not a binding rule.
So let me get at this a little bit differently. This process, whether it's as the process of responding to the August request was approved at a pretty high level.
Yes.
Assume that the injunction were lifted, the district court's injunction were lifted, and ICE came back with an identical request with a new list, a new spreadsheet. Could a lower level official approve the request based on the determinations reflected in the August decision?
No, I think the lower level official would be guided by the memorandum of understanding, which is what reflects IRS's policy and by the statute, but
So
not
could a lower
by
level
the
official look at it and refuse the request, saying, well, there isn't really a specific justification offered here?
certainly.
They could.
I would think certainly, yes.
They could. Is there any situation before where the IRS has accepted a single high-level request letter and spreadsheet like this as a justification adequate under section 6103,
Your Honor, I can only speculate.
multiple requests.
I don't know the answer. But what I can say is this is the first time IRS had implemented the policy reflected in the memorandum of understanding. And as we've said, it didn't do so perfectly. There were problems with its implementation, but it was the first time IRS had ever implemented that policy that's reflected in the memorandum of understanding. And the intent has always been to require a name and address. And that's pretty clear from the communications between the Treasury officials back and forth with ICE officials.
So when you say a low-level official could make a determination that a submission saying the same kinds of things that was said here in the long letter was insufficiently specific, they wouldn't need some higher level person to pass on that?
I don't believe so, Your Honor. And
So how does it go within the IRS? Who ordinarily decides whether a request satisfies the requirements of 6103?
I do not know the answer to that. I apologize. I'm not sure who has final decision-making authority here. What I can say is that the disclosure in August 2025 here was approved by the IRS commissioner. I don't think that the requests are generally elevated that high, but I actually don't know the answer to that. I'd be happy to.
Do you have any reason
Look
to
into
think
it.
if a request of similar scale came in, that it would not also go to the commissioner?
I think a request of this scale probably went to the commissioner because of its size and the novelty of it.
So that's a little bit in tension with your answer that if somebody got a similar request, that a lower level official, that they could deny it because it doesn't, in their view, it didn't give the specificity or it didn't explain direct involvement in the law enforcement action as required by the.
Well, I think my answer is that the
You said lower level official could say this isn't specific enough.
well, they wouldn't be bound by the previous disclosure.
But they could
is what I-
decide it
was what I was, right. It would be a new request that would need to be reevaluated to decide, whether it complied with the requirements set forth in the memorandum of understanding and the statute. But there wouldn't be any binding effect to the prior August 2025 disclosure.
It's the data exchange overview. Isn't that the process for dealing with requests?
I guess I disagree on that point. The data exchange overview was IRS's attempt to implement the policy reflected in the memorandum of understanding.
Was this something that was, I had read the record, but tell me if I'm wrong, that IRS and DHS, they had some back because the plan was that there were going to be requests that were large mass requests. How are we going to process these? And obviously, computer programming was undertaken.
Yes, and that, as far as I'm
That was
aware,
done
the
between
record
the
doesn't,
two agencies?
no, Your Honor, not that the record doesn't
This is
show
just by
that
IRS.
that is my understanding.
Okay, so they didn't have any, DHS, they didn't,
Sorry, excuse me.
they didn't have any idea what DHS was going to send over when they designed this? They didn't really talk to anybody at DHS about that? I would think you would want to know what information we're getting in what format before you design a computer program and a processing process, forgive my redundancy.
There was back and forth as to what information DHS needed to provide and specifically information that would comply with the statute.
Yeah.
And the administrative record contains some of that communication.
Yeah, what's the minimum to comply with the statute? And minimum compliance is still compliance if it is actually in fact compliance. And then this wasn't an oops, it's our first one, we got to work out some kinks, right? This is a formal program. Obviously, there's computer coding going on here. There's things that will be rejected as errors or things that are required for processing, things that are not. All of this was very calculated.
You know, I'm not aware that this document, Appendix 462, I'm not sure the record even shows us who reviewed it, who approved it, whether there was any sort of approval process.
It just exists.
It's a document that someone created in an effort to implement the policy reflected in the MOU.
It's a pretty
And it's
detailed
imperfect.
process. And in fact, there's another document that's the where they do some checking, some quality control. That's at 466-67. So this wasn't somebody just sitting in their cubicle on their own. This is computer programming, right? What has to be in, what's going to throw up an error, what's not, all this stuff here. It's multiple pages of programming of steps that are going to be taken, what information is required. Right. So this isn't just whoops, the computer did something wrong. Someone decided that when the statute says address, we think just having 5 digits in the zip code boxes and an EIN, TIN number.
Well, I think the thinking
And those, by the
was,
way, those can be any old numbers. It's not, we didn't even program it to verify whether that was an actual zip code.
well, I think the thinking was, is that that would serve as an accurate proxy. And obviously we've learned that's not the case in hindsight, Your Honor, but
I'm just saying, you've got something here was done within the agency. It looks like a very formalized process.
I'm not,
There's architecture overviews of this. This was not, whoops. Someone put some wrong information in the first time and suddenly hundreds of tens of thousands of addresses are disclosed. This is a very formalized process and document that was, the Roma Declaration tells us. It tells us this is what we used.
I mean, I think we'd have to speculate a lot to really know
Well, you're the one who
what
wants us to
process
say
this
it.
went through. But
Counsel. Your client produced this document, right?
yes, Your Honor.
It produced it in response to either a document request or I'm not sure exactly how the district court organized the hearing, but your client produced it because it was relevant, right?
Yes, and it
So
certainly is
don't
part
come in
of the,
here and tell us that you don't really know what significance this document has. If it didn't have any significance, then your client wouldn't have produced it.
well, what I'm trying to say, Your Honor, is I don't know what sort of review or vetting or who would have, or if there would have been approval of this
It
specific
obviously
process.
had adequate vetting because it was relied upon and your client produced it to have a court consider it.
I agree it was relied upon. I agree.
You have a document that has different information that was vetted better that you can show us that's relevant.
No, your point taken, Your Honor. Point taken. I agree. I guess my response still would be, though, even taking this, even if we were to assume that this document accurately reflects a policy of the IRS, again, for the same reasons, the memorandum of understanding is not a final agency action. This document and the policy reflected therein also would not be a final agency action because aliens are already required to provide their address information to DHS.
So tell me this. Is there a document anywhere that reflects the current policy of the Department of Treasury with respect to address sharing?
Yes, and that would be the memorandum of understanding. That is the IRS's policy.
So I'm trying to understand how you are defending this case, and I have some questions for the appellees about how they're litigating this case, because a lot of it doesn't make sense to me. But it seems to me that you're litigating this case kind of the way that the government litigates cases where maybe there's like, allegation of police misconduct, a bad search or something. And there's a civil suit where you say, well, the police officer might have made a mistake in, searching this residence, but the government isn't liable because they didn't follow their training. They didn't follow the policy. So we as the government aren't liable. Maybe the individual officer is liable for violating someone's rights because our policy is different and our training is different than what was implemented and executed by this one official. It sounds like your defense here as to why there's like no final agency action is a little similar, where you're saying, well, to the extent that there is a policy, it's in an MOU, and this document at A462 can't really countermand the MOU, and the MOU is consistent with the statute. And so the only kind of action that can be challenged is the particular implementation that may have been flawed, but they aren't challenging that. They're challenging a policy, but the policy either doesn't exist, or to the extent that it exists, it's the MOU. Am I understanding your position correct?
Yes, Your Honor. Like to the extent plaintiffs wanted to challenge the August 2025 disclosure, the government would readily admit that there were mistakes made, that some information was disclosed not in compliance with the statute, but that's not what's happening here. The plaintiffs are arguing that IRS has some broader policy to make disclosures even when an address is not provided.
I think that what they're saying is that the policy is to do what you did. The MOU may say one thing, but, you know, the real policy is to do something broader than what the MOU says.
I mean,
we know that because that's what they did, and it was signed by the commissioner of the IRS, no less.
I think that may hold sway if this had been something that had recurred time and time again. This happened once in August 2025. IRS admits that there was error in implementing that.
Who admits it? Did the commissioner admit it?
No, the government, the Justice Department.
Well, I guess all I'm saying is that the plaintiffs are saying that the agency maybe have written down one thing in the MOU, but the agency is really doing something else. And we can see that because of what they did. And there's no reason to believe that they're going to do anything differently in the future. So saying that, well, the Justice Department said in some papers that's not going to happen again doesn't really answer the question of whether the agency is going to do it again. One would think that the agency, there would be a declaration from someone in the agency saying, no, that wasn't right, and we're not going to do that anymore.
Well, and I think that's the Romo Declaration. I think that's exactly what that is. So I agree.
So if this were to ever happen again, you're saying then that a district court would have a basis to hold someone in contempt for essentially acting in accordance with a declaration that was filed with the court to get a court to either vacate an injunction or to reverse an injunction.
Yes, Your Honor. I think the district court in that situation, that there are consequences for failing to comply with Section 6103. And a district court could bring those to bear in a case of a wrongful disclosure. So I think that's correct.
Can you tell me, Mr. Christensen, what role does ICE play in investigating or prosecuting criminal violations of 1253A? I know it has civil enforcement authority. Does it have,
yes.
What role does it play in the criminal enforcement of
yes,
AUSC 1253A?
Yes, ICE has criminal enforcement authority, as we've explained in our opening brief on page 6. 8 USC 1103A authorizes the Secretary of DHS or charges her with enforcement of the nation's immigration laws. Then ICE officers are immigration officers under 8 USC 1101A18 and under applicable regulations, and they're empowered with law enforcement authority as set forth in 8 USC 1357, which includes the authority to arrest aliens in violation of section 1253A. And that's in our brief at page
So it's just the
6.
arresting. That's the role they play.
Well, arrest
I mean,
and investigate as well, violations and enforce
Do they
the
make
statute.
referrals to, or they do the whole prosecution themselves? They make referrals to the Justice Department?
I actually am not aware.
Really?
I'm not. And maybe
Like,
more
do they make,
importantly,
you don't know whether they make criminal referrals to the criminal division or any other part of the justice?
well, eventually, I think the U.S. attorneys are involved from the Justice Department are involved when
If they have to go to
prosecution, if a prosecution comes to court, that's my understanding.
And is there any threshold or any policy or any standard for making criminal referrals?
Again, Your Honor, I would not know, but more
That's so
importantly,
strange to me that you don't know, because the statute that we're looking at here has to do with investigating or prosecuting. Doesn't it have to do with investigating or prosecuting criminal?
Your Honor,
violations?
I wouldn't know, but more importantly, IRS would not know either. I mean, IRS's role under the statute is a very limited role. Congress has said that IRS shall disclose information upon receipt of a request that includes the specified information. And so IRS is not given discretion under the statute to question or to second guess or to conduct its own
No,
inquiry as to
but
whether the
But
representations
they
are.
have to be given a specific reason or reasons why disclosure of the requested information is or may be relevant.
And if that information is in the request, the statute says IRS shall disclose upon receipt of that request. So that strongly indicates that Congress didn't expect that IRS would substitute its own judgment for that of ICE in deciding what is or is not or may be relevant in a criminal investigation. The gatekeeping function under the statute is actually the requirement that any request must come from the head of the agency, and it must be in writing. And that's the way that Congress ensured that requests under the statute would not be made inappropriately or with impunity.
Right, but if
Because
one is in the IRS and is assessing reasons given by ICE why the information that they're requesting from the IRS is or may be relevant to a proceeding or investigation, don't they have to have some understanding of what kind of proceeding or investigation is at issue?
Your Honor, I would
We're
say,
talking about disclosure
as I've just said, Your Honor,
for use in criminal investigations.
Yep. So if a request designates, the request merely has to set forth information as required in the statute, which includes the specific criminal statute. And it has to include a specific reason or reasons why the information is or may be relevant to the investigation.
But here, the only reason, specific reason why the disclosure sought is relevant is just boilerplate. It's potentially at issue to prove a violation of deportation order, 8 U.S.C. 1253A1. And we're talking about criminal violation. So why does ICE need it to prove that? And we don't have any understanding of ICE's involvement in a criminal prosecution.
So my first response is IRS isn't the one making that call. It's the head of the agency who includes that information in the request. And once there's a compliant request.
Head of ICE?
Head of ICE, yes. And once there's a request that has that information, IRS is obligated to disclose upon receipt. But here the information
has that information, the only information, there was no specific reason or reasons why disclosure of, any individual on the spreadsheet's address was relevant to a criminal investigation. It just says it's potentially relevant.
I disagree.
That seems completely bootstrapping and circular. There's no information given, like, we need your address information. We have some address information. We need your address information for this standard time interval from 2022 to the present. because, it doesn't say because we needed to talk to people, because we have reasons to think our address is incorrect, because we plan to go arrest that person. Because, I mean, there's just nothing explaining a specific reason or reason.
Well, in addition to that, so the request came in the form of a written letter, which includes the language Your Honor has referenced. But also part of the request was a data request, or the data file that was submitted along with the request. And the data file included also additional reason, which was to verify presence in the United States. And the excerpt of the data file is appendix page 434. So ICE was requesting address information from IRS in order to verify presence.
Tell me again the page you're directing me to.
Yes, this is appendix page 434.
Presence or unlawful presence?
It just says to verify presence in the United States of America.
Nothing
And that's,
unlawful about being present in the US if you're still going through, you don't have a final removal order.
well, all of these individuals did have a final removal order.
Defined final.
All the 7 million in the first.
That's correct, Your Honor.
Final
In
as
fact,
in
the
BIA, no Court of Appeals stay, would define final.
I don't know. It's not
Regulations
in the
don't say.
record. It's not defined, but what
No, it is defined in the law. And it's either, it's got to be signed off by BIA, time to appeal has run. And obviously it wouldn't include one if the Court of Appeals had given a stay. So how do they?
yeah, what the memorandum of understanding says is
It's
that
not criminal until they've overstayed 90 days.
DHS, the memorandum of understanding explains that the aliens have been illegally present in the United States whom they have represented are under final orders to remove them from the United States.
But it's not a crime unless they're here 90 days after. One, you have to have a final order of removal. You don't know if you actually had final ones. Two, you don't know if they were 90 days. Or are you representing that everybody in the file ICE had calculated was here more than 90 days?
Yes, in fact, the
Yes, they
record,
were all here in over 90 days.
well,
Or that was
those are the
the IRS?
individuals who, no, there may have been some in the data file request that had not overstayed yet by 90 days. But the criminal statute 1253A1 includes additional violations. The 90-day period is not the only violation. An alien
What
can also.
other one is cited in the request that was submitted?
The statute,
Data file.
it's the statute that was, the statute cited is 1253A.
Which is the overstay one, right?
That's included, but also an alien can violate that statute by failing to timely apply for travel documents, or if the alien fails to present himself at the time and place that the Attorney General has ordered pursuant to a final order of removal.
And you're representing that individualized determinations were made for all, I forget, was it 700,000 in that spreadsheet?
I'm representing that the purpose of this request was to verify whether individuals who are under and subject to a final order of
They sought
removal,
travel documents isn't going to be affected by.
if they were still present in the United States. And all that's needed is that the
Okay, but if you're
information.
just prosecuting the unlawful presence, then they have to have overstayed by more than 90 days. I mean, there's a whole program line where
Or-
the date must be more than 90 days from the removal,
I agree.
the final order of removal.
And I think that's the emphasis, but you asked if there were individuals included that had not yet completed the 90
That's
days.
the basis for the reason they're on the list. There's individualized determinations. Are you telling me that's what it is?
In the
The
memorandum,
only thing programmed in here is, let's make sure there's a final order of removal.
Mhm.
We don't know if it really was final, and that they've overstayed, add 90 days or 91.
all we have to go, all the IRS has to go off here are the representations made by DHS.
Mhm.
And those representations are included in the memorandum of understanding on the first page in the introduction, where DHS has identified numerous aliens illegally present who DHS has represented are under final orders to remove. This is A372 in the appendix.
Or you have the
And paragraph-
letter from Todd Lyons, this is ipso dixit, this is
Also,
in order to fulfill our role as an agency in enforcing immigration laws. It's way too high level, nothing individualized. That should have alerted somebody.
Well, there's
Right.
also, again,
Why is the program set up to say, is there a, one of the things the computer has to check is there a final order of removal? You're not even really sure they were final, but let's assume they were on that. Make sure it's more than 90 days. And we know that at the time, we know from this record that at the time these were submitted, there were folks on there who had not yet hit the 90-day mark. You know how we know? Because the record shows that, oh, we ran it again yesterday and a few more people got added to the list because they weren't at 90 days when it was sent to us by ICE. But now they are.
As I said, Your Honor, there is more than one way to violate the statute that's been
Are you representing
designated.
that individualized determinations were made that add to those people that were not yet over 90 days at the time this massive file was sent? An individualized determination was made that, yes, but this one hadn't yet sought documents? This one hadn't yet appeared somewhere?
Well, all I can say is what DHS has represented, which is that those individuals,
Well, that's the problem.
they're under investigation under the statute. And the statute includes more than one way to violate it, which is
Just to make
failure.
your case harder, not to help you. The very fact that there's multiple
Mhm.
different offenses, different ways factually to violate 1253, and therefore different facts that would be needed to establish a violation.
But
It seems like where there's a requirement in the statute, in the taxpayer information release statute, to give an individualized determination of the need for it, that it seems like it's the boilerplate recitation of, there's a need for this to comply with this statute. Just, it really doesn't seem to give us anything
my response is that
specific and individualized.
a person's continued and current presence in the United States is relevant to all of those potential violations under section 1253A1. If a person has a final order of removal and they are still present in the United States,
Or if they don't have a
That's-
final order of removal.
even if some of them were just approaching the 90 days, they're, like I said,
We don't know how long.
we agreed.
Do you
Your
know
Honor.
how long?
Agreed, I don't.
No, it could have been.
And then the record doesn't tell us.
A person's continued presence, a person who ICE claims to have a reason to know is here unlawfully, is still here unlawfully. That's what they're trying to tell. That's what they're trying to find out.
That's what the ICE represented in the request, to verify presence in the United States. And if a person is still present, that is certainly at least relevant or probative to a potential violation under the statute.
What's your theory about the point of contact in the data file? It's one person for all these 1.2 million, or I guess it was like 50,000 or something that were actually produced. The same person is identified as personally and directly engaged in the criminal proceeding or criminal investigation. What is the theory of how that one person was personally and directly engaged in these tens of thousands of people's cases?
Yes, and we've set this forth in our briefing, which was that this initiative involved a large-scale investigation into potential violations by many individuals. And it began with a high-level review where this person, the Assistant Director of Enforcement and Removal Operations, would have been the person making the decisions and leading and in charge of that broad-scale investigation. There's evidence of that in the record on page 338 of the appendix. This is the initial contact when ICE reached out to IRS and explained, there's an internal IRS email that says, hey, we've just been contacted by an ICE assistant director. Again, this is appendix page 338. We've just been contacted by an ICE assistant director regarding IRS assisting in an ICE-led effort to locate approximately 700,000 individuals who are all under final orders of removal. This effort is being called a lead targeting cell and is being run out of the ICE headquarters in DC. So this gives you a feel for the large scale of this investigation, and then appropriately so, it was being led up by an assistant director of enforcement and removal operations.
So
That
they're
was
involved
Mr.
in,
Williams.
they're involved in a criminal investigation at an early stage in a kind of en masse.
That's right.
And how is there reason to think that people who don't have an order of deportation yet, I mean, criminal involves some knowledge on the part of the defendant, right? How is there reason to know that, for example, if it's a failure to appear or a failure to present certain documents that the individual has knowledge? Like I had been really focusing on the component that is that they have an order of deportation, so you can get infer knowledge from that, because if they have the order, they know they should leave.
Right. Is that your question? Yeah, because these
The
requests.
other offenses that you mentioned under 1253 A1, the other ways of violating, how do we know that people have knowledge if they haven't been given an order of deportation?
So all of them were under final orders of removal. So that's the baseline. All of the
You said they
individuals in the
weren't all.
request. No, they were all. The question was, were all of them already past the 90
Oh, right.
days?
Got it.
And some of them weren't. Yeah, not all of them were passed, but every individual in the request was under a final order of removal. And so this was a large scale initial high level review investigation that later would have been delegated. And additional staff could have been appointed as appropriate in order to conduct individual investigations with respect to certain individuals, but it began as a high level investigation.
Can you tell me, sorry. Where in the Romo Declaration, it says this data exchange overview procedure has been withdrawn?
Where it's been dropped? Was that the question?
Or changed?
What I glean from the declaration is that IRS is admitting an error in the implementation of the policy.
Yes.
What action IRS has since taken to remedy the error, I could only speculate. I'm not aware of what, if any, action IRS has done to correct the remedy.
So as far as you know, there's nothing in the record that says this has been withdrawn or replaced?
The data exchange overview, I'm not aware of how.
Program, which is what you have to process these mass requests.
The Roma
on data sheets.
Right. What the Roma Declaration says is that IRS is attempting to remediate the error. It reached out to DHS.
Continue to work to make sure they comply with the law, which is what we were told in O Central.
Right. IRS reached out to DHS and requested that they take steps to prevent the disclosure or dissemination and to ensure appropriate disposal of the data. So IRS is working to remediate that. As far as changing the computer process, I could only speculate what's happened.
I mean, a computer process just like this is going to have to be adopted if you're going to run these mass numbers based on these. They're just sort of computer inputs that you're getting from DHS. So as far as the record shows at this point, this is neither withdrawn, changed, or replaced.
Well, I think IRS recognizes that it's problematic and would not, I would imagine would, given the error. I think I can fairly say that IRS would not be using the same computer system in the future.
They've had plenty of time.
Well, they've been enjoined.
They're enjoined from processing ICE requests. They're not enjoined from fixing their own internal errors, are they?
Again, Your Honor, I don't know.
Does the injunction anywhere from this or the one from the other court prevent you from fixing your computer program so that if in one injunctions lift?
Your Honor, I'm not aware what action IRS has taken in that regard.
More questions at this point? Sorry. All right. Thank you. Thank you very much for all your extra time.
Thank you.
Good morning, Your Honors, and may it please the court. My name is Madeline Jatomer on behalf of the plaintiff appellees.
And before we get into more nitty gritty, counsel for the government has said they have no objection to this court supplementing the record on appeal with the Romo declaration under FRAP 10E2.
Yes, Your Honor.
Do you agree, object, have a view on that?
We have no objection and believe it should be added to the record.
Okay. Please, sorry for the initial interruption.
Not at all. This court has repeatedly held that a policy need not be written in a formal statement to be agency action, and the district court committed no clear error in finding one that exists here. As Your Honor mentioned, this record is replete with evidence showing that the IRS has changed the way it evaluated requests under 6103. As this court mentioned, A462 is one piece of evidence that demonstrates that. In addition, the Internal Revenue Manual was changed shortly after the MOU was entered into to reflect a change in policy. The district court made a factual finding that there is uncontested record evidence that the IRS spent money developing the technical capability to conduct mass transfers, actually made those transfers, and that any IRS official that stood in the way of implementation of that policy was pushed out.
The difficulty I have, Mr. Toner, with that analysis is that this was a major request for whatever 1.2 million or, pieces of information. One would do some software building. You would have to do some to respond to that request. So I'm not sure that creating new programming and new method means that it outlives the response to that request. And that seems to be because you're here seeking future regarding relief, injunction, declaratory relief. And so the question is this legal analysis that was done for this request have an afterlife? What's the best evidence of that?
I would point the court to A440. This is an email that where IRS acting counsel evaluated this request for this request, which is actually 1.2 million requests. I think that the new policy has two parts. The first part is that the IRS has shifted from individual review of each request to make sure that that individual request meets the requirements set forth in I-2 to an evaluation of that request at the 1.2 million person level. So does that request include a data field? Does the letter and does the spreadsheet that Mr. Christensen mentioned have a field for addresses? Does it have a field for the relevant tax return years? If that's met, then the process moves to computer processing. That is contrasted by the process that was laid out in the manual pre-April 2025, where each individual request or each handful of requests, maybe 5, were assigned to a disclosure manager. That individual at the IRS was required to ensure that the requirements in I-2 were met, communicate with the requesting AUSA to determine the specific reasons for which it would be used, and then submit a memo to determine whether that request should be effectuated.
Again, right. We know that they did something different.
Mm-hmm.
They got a size of request that was dramatically different. They dealt with it in a very different way. If we accept all that, we still have the question, are they continuing to process? They gave a pretty moderate response rate to what was sought. Do we have any reason to believe that the service is continuing to process the request with regard to the balance of the 1.2 million over, what was it, the 700,000 that they did deal with, or that there's any continued use with respect to this request?
I would say two things, Your Honor. First, there is no evidence that they are not interested in continuing to process this or similar requests. And we know that because the Walker Declaration in the record says that it finished at that time, but had not, but makes no commitments as to future processing. And I think that's also evidenced by what Judge Millett said, which is that the IRS continued processing because it noted that more individuals were then pulled into the response because 90 days has expired. The IRS has made no representations at any point in the record that they are done processing this request or any others. And I think there is significant record evidence, to your point, that they have changed the way they process information under I-2. I think that is sufficient.
But what we don't know is it a bespoke change? You know, we get this unprecedented effort on the part of ICE to enrich its database. It's going to go and, scrape what it can all around the government. And this is what they got from the IRS. We don't know whether this is an ongoing system or whether it's just like, we're going to throw the spaghetti at the wall, see what we get, and move on. And you're right, they haven't foreclosed the notion that they could continue to abide by this legal advice. They could continue to do things according to the template that they effectively developed here. But we don't really have something affirmative saying that they will, and or do we?
I think the record taken as a whole shows that they didn't just throw spaghetti at the wall once. They've thrown it many times, and the IRS has worked hand in hand with ICE to ensure that it could process its requests under this new process. So I think the district court found that this technical capability was not built solely for this in response to this request. It was built in response to an effort which it calls in the record at A473, an on-demand process to provide address information to ICE. There's nothing in the record that shows that that's directly responsive to this request. Instead, this tracks back to February, and then when the MOU was entered in April, an effort by the IRS and ICE to create a new process under I-2 to evaluate requests so that address information could be disclosed to ICE.
I think JA 473 through 77. Whole table of contents, ICE exchange overview, architecture overview, internal output, and then discussion points include volume and frequency of the data we are expecting. They're expecting this to keep coming, are they not?
That's correct, Your Honor.
This is not a one-off. One doesn't create this very complicated architecture, computer architecture, programming architecture, I guess is what it is.
I think that's
one of the things to discuss now that we've got that in place, the volume and frequency of the data we are expecting.
I think that's exactly right. I'd like to make two other points, Your Honor, to add to your point there. The first is that I don't believe the changes to the Internal Revenue Manual would have been made in April in anticipation of one unknown mass request that came in June. I think there was, again, this mass request could not have been processed under the IRS's previous policy for how it was going to evaluate requests under I-2.
What in the manual substantively was changed?
There are two provisions in the manual that were changed. There was a process by which I-2 requests were evaluated, and then there was a checklist for processing requests under I-2. The checklist itself was just removed. That checklist included steps like the assignment of an IRS disclosure manager to each request and a requirement that that disclosure manager discuss that request with the requesting officer. In the manual, it stated AUSA because that was typically who was requesting the information. In addition, it laid out a process by which that manager then sought approval through, for example, submission of a memo to determine whether that the requirements of I-2 were met. I do want to address Mr. Christensen's point that the IRS needs to take at face value the information it receives. I don't think that's what 6103 requires. This court has said that section 6103 of the Internal Revenue Code requires, regulates minutely the disclosures of tax information under 6103. And so the idea that the IRS must look at the headers in a spreadsheet and determine that if those headers include the required information in I-2, all of that data can be disclosed. I think that misreads the IRS's obligation to enforce its own statute.
Can I
Say
take
more
you-
about what, go ahead.
Can I just get your response to the government's arguments? And I have some concerns myself about standing and irreparable harm.
Absolutely, Your Honor. I'd like to start with the Center for Taxpayer Rights. The address sharing policy harms the center because it impacts its core activities. Are its legal representation of clients, pro bono representation of clients, and its education and outreach. And the center has used its resources to counteract those harms. The district court made a factual finding that there's been a dramatic decline in the center's abilities to provide its services. So for example, in 2024, I should note that the center is required by statute to serve immigrant communities. And the statute uses as a proxy for immigrant communities, ESL taxpayers, that's English as a second language, and ITIN taxpayers, that's individual tax identification number. And so the statute requires that any low income tax clinic serve those taxpayers. In 2024 and in years before.
I'm sorry, an individual taxpayer number is a taxpayer number for someone that doesn't have a social security number?
That's correct. And in many cases, those are immigrants. In 2024, the center served 14 ITIN. The center represented 14 ITIN clients in disputes against the IRS, 16 ESL taxpayers, that's collectively including the 14 in front of the IRS. In 2025, that number dropped to 1. In 2024, the center held 10 events focused on the rights and responsibilities of ESL taxpayers. In 2025, they were only able to hold 1. This is not a case where the center spent its way into standing. This is
My
not.
understanding is that the district court only evaluated standing with respect to the center and not with respect to any of the other plaintiffs. Do I have that wrong?
The district court did also address associational standing.
Associational standing with respect to the center.
My understanding is that the district court determined that there was a substantial likelihood that the plaintiffs as a whole on behalf of their members, so the Main Street Alliance, who indicated that they have members that file with ITIN numbers, that there was a substantial likelihood that they would be able to show standing on behalf of their members.
I mean, I read the footnote in the district court's opinion to acknowledge that the center doesn't have members, but that the district court was kind of proceeding kind of almost as if it really was a membership organization anyway.
So I read that footnote to say that the district court was not reaching the question of whether the center has members. What I will say is that the center does run an LITC network. That's a network of other clinics that it serves. At the district court level, the center did argue or did present third-party and associational standing claims, but the district court did not rule on them. But I think that's not dispositive here. I think that it's very clear that the center has organizational standing because its core business activities are not ones that are related to its opposition to this policy or advocacy against this policy. These are its activities activities that it has been conducting for a long-standing period of time and are in accordance with its mission and its statutory obligations.
So even if we accept all of that, how is any of this irreparable harm?
So I think the center's irreparable harm, is certain and great because it's not imminent. It's not about to occur. It has already begun occurring. We know because the center's clients have told the center that they are unable to engage with the tax system. They are fearful. It has chilled their engagement with the tax system. And that's irreparable in a few ways. So first, as this court said in Alpine Security Corporation, where a business is destroyed in its current form, that commonly qualifies as irreparable harm. Here we have an organization that is unable to provide its core services because of the impact of a policy on its clients. That's very similar to what the Supreme Court found in Department of Commerce versus New York, where the court found that inclusion of a census question was an obvious cause of a chilling effect on individuals that affected states, right? So even where the Census Bureau was required to protect that information, the court found that third parties reacting in predictable ways, or as the court said in Dominion Alternative Energy, in common sense and predictable ways, that is enough to infer causation where there's not direct regulation of the organization itself. And so to go back to your question on irreparable harm, I think there's the district court, I think, found 4 types of irreparable harm. First, that the trust engendered between the Center for Taxpayer Rights and its clients is difficult to measure, but more importantly, difficult to replace. So where the clients have for years trusted the center, and where the center advises them on the protections that exist in the tax system and encourage them to participate in the tax system, right? I mean, many courts have identified that the tax system is the lifeblood of our government. So where they have encouraged participation in that tax system, and then an unlawful act harms that trust in ways that can injure that individual, that's an irreparable harm to the center because it erodes the trust between the center and its clients. Like I mentioned, similar to in Alpine, it threatens the existence of the pro bono legal services program and their education and outreach program with respect to ESL taxpayers. It also threatens federal funding. So another basis on which the district court found standing and irreparable harm was because it found there was a substantial likelihood that the center could lose its federal funding with respect to its low income tax center. Now, that funding is contingent on the center meeting its goals and showing substantial progress towards meeting its goals. Those goals are not ambiguous. Each year, the center needs to report to the IRS very specific metrics with respect to engagement with this set of taxpayers. So for example, every year they need to report to the IRS the number of consultations they have with ESL taxpayers, the number of disputes in which they've represented clients in front of the IRS with respect to ESL taxpayers. There's a list of almost a dozen metrics with respect to ESL and ITIN taxpayers, and in every one but one of those metrics, the center is down compared to last year. And so as opposed to being able to show progress, it is showing that it is harmed, and it is actually reversing its progress as a result of this policy. And again, we know that this policy is the cause because that is what that is what the clients of the center have told the center. And we know that's at A186 and A317 in both of Ms. Olson's declarations. We also, I'm sorry, Judge, the last point I would make is that the district court made a factual finding crediting the public reporting, the significant public reporting on the policy, and crediting the fact that immigrant taxpayers know about the policy and are chilled because of it.
Thank you.
So, so we have a case called League of Women Voters, I think, versus Newbie, in which we found standing where the league, which was its mission was to register voters, and the new requirements for citizenship documentation were driving down the number of people it could reach out to, people it could get to register, just driving people away from their registration events. Is that the theory you have here, sort of driving away the client base?
Yes, Your Honor. That is, this case is on all fours with Newbie. I appreciate you raising it because it also reminds me of the fourth type of irreparable harm we have here, which I failed to mention, which is that in Newbie, the court said there was irreparable harm because there was an upcoming election, right? The harm that with respect to that election could not be undone after the election had passed. And like that, here, the IRS has deadlines in place. So we have clients who are walking away. I'm sorry, the center has clients who are walking away from tax credits and refunds to which they are entitled. And there are deadlines by which they must apply, or to engage in a dispute. There are statutes of limitations and deadlines by which they must engage with the IRS. As time goes on, those deadlines pass and they cannot be made whole. In addition, for these taxpayers, I want to make 2 points. The IRS says repeatedly that everyone is required to pay taxes, and so this is not a voluntary tax system. But this court and others have reminded us time and time again that this is a voluntary system. Congress intended for 6103 to place stringent protections on this data because the voluntary participation in our tax system depends on it. And that's important here because the harm to not receiving a $500 credit is irreparable, for example, to someone who makes under $15,000 a year and thus is not required on an annual basis to file taxes. If they are below the refund limit that the IRS sets each year, there is no requirement that they file taxes, but it's important to our voluntary taxpaying system that they do participate. And in fact, the district court made factual findings here that this year alone, the policy would result in nearly $12 billion of revenue loss as a result of the policy.
So I don't have one standing, but
Go ahead.
so on the policy, you've heard your friend on the other side say there really isn't a policy other than the MOU, and that your complaint doesn't challenge this specific disclosure. So it's checkmate because we held in Centro that the MOU is not a final agency action. And to the extent that a decision made by an official to make a disclosure could be final agency action, you're not challenging any specific decision made by an official. So what's your response to that?
I think that I have a few responses. This court has found that an agency cannot evade judicial review just because it has not written a policy down in one place. And here this policy is written all over the record. This is not an instance where in April, there was an MOU entered into, and then in late June, the IRS received a request and decided how to respond to it. The record shows that there is a concerted effort of development and then implementation of a policy, which includes A462, that that built the capability to process these types of requests and then implemented that process with respect to not just this request, but others. The other requests never got to the second step, which is computerized processing. But as in Hispanic Affairs project, where there are repeated practices, so where IRS counsel, for example, was pushed out because it said that the same 1.4 million request that was approved at a high level by IRS counsel at A430, the IRS counsel at that time, chief counsel, declined to move that request to the computerized process stage because it said that same request didn't meet. So there was a clear effort here to create a policy, a new process by which this information would be disclosed. I think the numbers also speak for themselves. So in our district court briefing at A96, we talk about how the IRS is required to disclose to the Joint Committee on Taxation the number of disclosures it makes under I-2 per year and to what agency. From 2018 to 2024, there were 0 disclosures made under I-2 to DHS or ICE. Just 2 weeks ago, they submitted the report for 2025, and that report showed that the under I-2, the IRS made more than 47 disclosures to DHS and ICE. That is more than half of the total disclosures last year from the IRS to ICE, and it's more than the total number of disclosures for almost every year from 2018 to 2024.
What do you make of that 47 disclosures number? There's either, I don't know, tens of thousands or one, like, what are they referring to?
So
are they identified?
Sorry, the 47,000 number.
Or 47,000.
Yeah, I apologize.
I thought you said 47 disclosures.
I apologize if I
said 47.
It was the exact number that are issued here.
Of lines in the spreadsheet that were responded to.
That's correct. One thing, if your honors don't have any other questions on that, I would like to quickly, yes, your honor.
It's still on this question about policy. You point to changes to the manual, but as I understand it, the manual is not binding and there's case law so holding. You refer to these sort of discussion points and draft workflow chart at A76, A77, volume and frequency of the data we are expecting. This is by, I guess, the tech people, presented as a draft, as discussion points. I take it you're not saying this is the policy. You're saying this is evidence of an unwritten policy? And the manual?
I think that's correct, your honor. I think that there is significant evidence in the record, but I would point to 3 places in the record that I think are most reflective of the policy. It is the Internal Revenue Manual. Those citations are discussed at A91 in our briefing. It is the DHS ICE data exchange overview at 462, and it's emails like that at A440. Those represent a meaningful change in how the IRS processed requests under I-2. I think the policy has 2 core features. First, it allows for disclosures under I-2 without any individual evaluation of whether each individual request meets the requirements set forth in I-2. And second, it abdicates the IRS's role in keeping tax information confidential as it is required to do by 6103. 6103 sets forth a general rule that tax information shall be kept confidential unless it meets all of the requirements, in this case, set forth in exception I-2. And in this case, the policy shift that is critical here is that the IRS no longer required that each individual request be evaluated to ensure that it fit each of the requirements set forth in that exception. I think that's what's notable here.
They're saying each individual request is being examined by algorithm.
And Your Honor, I'd make 2 points. One, that algorithm is insufficient here. So for example, if an individual was reviewing individually, let's not do 1.2 million, let's say the 47,000, each of those requests, it would understand that 00000 is not an address. And so I would say first, the computerized rules are insufficient here. And second, the rules. So yeah, I mean, I think I would say the computerized rules are insufficient for 2 reasons. One, they don't actually require that each of the I-2 requirements are met. And second, they don't involve the IRS in assessing each request. The IRS must do more than what Mr. Christensen contends. They must do more than rubber stamp these requests, particularly where these requests on their face are clearly beyond credibility. So for example, I think the address example is the most straightforward. No one here thinks that the policy requires an actual address to be submitted for each taxpayer. As Mr.
This process that they used for the August submission, August disclosures.
I would say the process that they developed for ICE requests under the MOU. I
The
would
statute requires that.
correct.
An actual address.
Correct.
You're saying the IRS's judgment isn't being brought to bear.
That is part of it. Yes. The IRS must do more than just rubber stamp. So for example, I'd also point the court towards the taxable periods of the return information. This is why the individual nature of this matters. For an individual who has a removal order from the end of 2024, an address from 2022 is going to do nothing to show that that individual has overstayed their removal order. But what the IRS has done here is said, well, collectively for 1.2 million people, this range is sufficient. I'll add to that the output that ICE is receiving, so the output of what the IRS is sending, does not attach a date or even a year to the address. So when ICE receives this information, they only know that this is the IRS's last known address. It provides no evidence as to when that address is from. It may be from 2022, 2 years before a removal order is even entered. It may be from 2025, but the ICE does not know. And so where a request is so—
You said IRS doesn't attach dates to its address?
That's correct.
I don't understand that argument to have too much force. I mean, assuming that they are making a request for whatever information that the IRS has for somebody and it's 90 days past a final removal order, whether the address was given to the IRS last week or 10 years ago, it still could be relevant to an investigation of them going to that address and seeing if that person is still in the United States when they're supposed to be gone.
So I would make 2 points in response to that, Your Honor. And first, Judge Pillard, I would just point you to A464 for the point I made before about what information is sent from the IRS to ICE, which does not include any year. But to your point, Your Honor, if the rationale for which they are giving this information is so that they can go out and locate the person, right? If that's the specific reason, it is then beyond credibility that one individual could do that, not only for the 1.2 million individuals in this request, but the 7.5 where that individual was also listed as personally and directly engaged.
But they could be engaged in the investigation and task that, to groups of people. We have all these addresses in, Iowa City. We're going to have paralegals in the U.S. Attorney's Office there go off and do it. I mean, you can be personally, whatever it is, and directly involved without being the only person who's personally and directly involved. I think that's the difficulty with that. And I think if this were a murder investigation, even if it's a stale address, you'd go there and find out, has anybody ever heard of this person? What do we know? Da, da, da. I mean, it is a little extraordinary that there's going to be follow-up on all of these folks. It's a little unclear. I get that. But the relevance doesn't have to be that it's going to be more recent.
I would make 2 points, Your Honor. First, I think you're right that there may be follow-up on all of these people, because what the White House spokesperson said is that this policy is part of the administration's goal to locate and deport these individuals. But what 6103 permits is disclosures for criminal investigations only. And that goes to my second point, which is that the IRS in its brief conceded that it does not have open criminal investigations for each of these individuals. They said that they are running an investigation. I would call it more of a dragnet or surveillance of vast amounts of what this government calls its most confidential data, to then determine, based on after the receipt and surveillance of that data, whether it wants to open individual investigations. Those are the investigations that I think this statute requires, because this information, as this court said in Centro, 6103 does not authorize the freewheeling disclosure of sensitive tax information.
I take your point, but if the government in its wisdom decides that rather than finding people who have overstayed the 90 days and have a final removal order, rather than use resources to prosecute them and put them in jails or whatever here in the US, it's just going to go ahead and remove them. How is that kind of abusing this statute? Because it's still a crime that they're investigating, but maybe they've made a decision and maybe they can announce to the world, we're not actually going to prosecute anyone who may have committed this crime. We just want to go ahead and effectuate their removal from the United States. How does that violate the statute?
I think that betrays Congress's intent in creating in 6103 in creating a statute that protects what it calls some of this country's most sensitive data. It's the Congress said in passing 6103 that the privacy of that data should be equivalent to an individual's papers within their own home.
So if there was a legitimate prosecution that could be had, that they could be using it to investigate, but they've said, look, we have a policy where we're just not going to prosecute any of these people. We just want to remove them because they do have a final removal order.
So
you're saying if that were announced and it's absolutely crystal clear that that were final agency action, it's written down, it's a rulemaking, it could be whatever the bells and whistles are, that we should strike that down because that would be contrary to law.
Here's what I would say, Your Honor. If ICE requested one address for about one individual, they conducted or were conducting a criminal investigation.
I want you to answer my question, which is what I described, would that be contrary to law?
With apologies, Your Honor, could you repeat the hypothetical?
There's undisputable final agency action that we are going to make these requests. And let's just say they're going to be one by one requests.
Okay.
And it's for persons that we know have a final removal order and it's more than 90 days, but we want to find addresses. And yes, we could prosecute those people if we found them for overstaying it, but we don't intend to do that. We just want to investigate whether they're here, and if they're here, remove them.
I understand, Your Honor.
Would that be contrary to law?
That would be contrary to law, because what the statute requires is that ICE provide the specific reason why it is relevant to a criminal investigation. And what you just stated is that the investigation is not criminal in nature. There may be a pending criminal matter with respect to that individual or group of individuals. But what you just stated, Your Honor, is that
So if they say that rather than prosecute the person, we're going to enter into, some sort of deferred prosecution agreement to them, to where rather than going forward with a prosecution, they will essentially kind of get a deal where rather than a conviction and potentially a prison sentence, they can leave. Is that violate is that contrary to law?
I think that is a closer call, but I don't think that's what's at issue here. I would go back to Judge Pillar's question to Mr. Christensen earlier, which is DOJ involved and what typically is their involvement? To the extent that there are those agreements in place, I think there's a high likelihood that DOJ would be involved. Where the requests for 1.24 million addresses are on their face clearly not pursuant to criminal investigations, I think that's a different question.
I guess what I'm trying to get an answer to you from is like, why does one have to read the statute to say that there has to be, because it says, I'm looking at the language. The person has to, it talks about an investigation which may result in such a proceeding. But I guess what language in the statute would you say that these hypothetical policies I'm beating you about the head and shoulders with, what language in the statute would you say it's violent?
I would say that in I-2B4, the IRS must receive the specific reason why such disclosure is or may be relevant to such investigation. The word investigation there refers back to I-1, where investigation refers to a criminal investigation. And so this country's promise has always been, and President Trump in his first term said that this information will not be used for civil immigration enforcement. And what the record shows collectively is that ICE is working with the IRS to try to cram a significant amount of address disclosures into I-2 unlawfully. I would.
So is it, and maybe this is oversimplified, but it seems like if you're ICE and you have issued an order of deportation, or whoever, the person has an order of deportation, the date of that order, and that 90 or more days has passed, you already know that the crime has been completed. There's no further investigation for that crime. So what they're using the information for is not for a criminal investigation. They're using it to round people up and deport them.
That's correct, Your Honor. And I think the district court made significant factual findings with respect to the substantial likelihood that ICE is or will be using this information in order to conduct civil immigration enforcement. There's also information in the record where ICE says that it wants this data to enrich its own records. And
so I guess the question is, I'm just answering, being devil's advocate on my own question, which is, okay, the crime of overstay is complete without the address information, but maybe not if they don't know whether the person is still in the United States. But then wouldn't they have to cull the data they have and say, we've checked whether these people are still here, here's the unknowns? Or
right. I mean, none of that is that is one element of the crime that there's no evidence has been investigated. I think in addition, I believe it's about 2/3 of removal orders are delivered in absentia. And so willful overstay is the criminal term. And there's nothing to suggest that they're doing anything to investigate that. And again, I just want to go back to the prior policy. That could all be discussed between the IRS's disclosure manager and the AUSA or immigration official investigating a crime to ensure that the statutory requirements are being met. But that process has been eroded here, and it's replaced by insufficient computerized rules.
Do you have any information, and I'll try to remember to ask this of Mr. Christensen too, any information of how often an overstay is criminally prosecuted?
Candidly, Your Honor, I did try to obtain that information and was unable to find it. But yeah, I don't have that information. Our belief is that it is a low number. And for example, there were not 47,000 prosecutions with respect to this last year.
Right. I guess what is sort of becoming clear to me is there has to be some nexus to a criminal investigation with the information that they're seeking. And the question is, what is that?
I agree with that, Your Honor.
More question? I'm just gonna have one more question, I think, on 444, Appendix 444.
Yes, Your Honor.
This is Treasury, I guess, / IRS versus saying, we understand that this letter, and that's the one from Todd Lyons with the spreadsheet of information. We understand that this letter, coupled with the data file, comply with the requirements of the MOU and statute. And so IRS should begin processing. Sorry, there's so many emails and stuff in here. Where was the decision made that we understand that this letter complies? Do we know who made that decision that it complies?
Yeah, so if I may, for one moment, just walk through the steps because it is hard to parse. So on June 25th, the spreadsheet that Mr. Christensen referenced was sent to the IRS. On June 25th at A4:30, at that point, Chief Counsel, I'll use his initials, AD, determined that spreadsheet did not meet the requirements. By June 27th, he was pushed out of the IRS. On June 27th at A4:40, there's an email from AM, the Deputy Chief Counsel, to IT.
June, which?
I'm sorry, it's on July 1st. I apologize.
July 1st,
A4:40. So
this Tyler email to cache it and personally identify.
it's from Morris on A4:40. That's what I have.
Audrey Morris?
Oh, sorry. Yeah.
And in the emails below that, a Treasury official says, IT says, I was told not to process this information until AD has signed off. And Treasury says, don't wait for that. Go to AM, which is Deputy Chief Counsel. This email is the one that says this has met the requirements and the IRS can begin processing the request. That request is the spreadsheet. And then on June 27th, the IRS sent a letter, which is at A4:49. So the request is the spreadsheet, which is partially redacted, coupled with the letter at A4:49. And I do want to just emphasize, I'm calling it a request, but we do need to be clear. It is 1.2 million requests rolled into one approval. And I think that is, a clear evidence of the change in policy here.
Okay, and then 445, you have the Chief Information Officer, Tech Officer saying, staff council met with repeating the Audrey Morris, met with the 6103 experts, and we're going to run it through our data exchange program.
That's correct, Your Honor.
So why is ICE not made a party to this proceeding?
This case is about the IRS's treatment and protection of its data. And so at the time this case was brought, that is where this case focused, and our clients wanted to focus. The Center for Taxpayer Rights' entire mission and statutory obligations are focused on the IRS's protection of data. And so regardless of what ICE has done, for example, if ICE wanted to send requests in mass, I don't think our clients would have objection to that if they were processed consistent with IRS policy. ICE can do what it wants, just like any other agency can with respect to requests under 6103, but the obligation to protect tax data is that of the IRS, and that is why our clients have focused on the actions of the agency.
And is it accurate for us to view your allegation of what is the final agency action as not the specific disclosure that was made in, was it June? Whenever it was made, August of 2025.
That's correct. The policy at issue is a policy that is written but scattered around the administrative record that allows for disclosures of confidential tax information to ICE under 6103 I-2 by evaluating requests in mass and never assessing that each individual request meets I-2 statutory requirements.
So if it was in mass and the algorithm was fantastic and it required really detailed narrative descriptions and every one of them had to be different and had to really match the data, that would be a problem.
I think that really depends on the facts. For example, if the algorithm had a way to confirm that as this court said in Centro, like not any address will do, but confirm that it is an address to whom the information relates of the taxpayer. If they could confirm that the reason for which the information was disclosed is specific enough, I don't think that would necessarily violate the contrary to law claims. I do think it would still be arbitrary and capricious because there would be a meaningful change in which the agency processed these requests and interpreted I-2 without explanation, without considering reliance interests. But I think that's very different than what we see here.
Well, would it be, if I had more confidence generally in the ability of an algorithm to do a great job, this one just was pretty blunt and careless, how would I analyze your claim? The policy is they used an algorithm that was inadequate to confirm addresses, that didn't purport to require a reason that was specific to the circumstances of the case. Anything else?
So I think the IRS would have, I do think the IRS would have to do more. The 6103 regulates in minute detail disclosures and must keep information confidential. And so I think it requires, perhaps for example, Your Honor, apologies, an algorithm could put out an output of 47,000 addresses, and then an individual disclosure manager reviews the requests and the disclosures to confirm that it meets the statute. We know that didn't happen here.
So maybe they could do the first cut and that would help the processing, but someone would still have to inspect.
Yeah, it would depend on the facts, but maybe. But we know here that the quality check that the IRS purports to do was, I think, 200 records of 1.2 million. I mean, what we're talking about is just a lack of IRS responsibility and involvement in ensuring that the statutory requirements are met. And that is a clear change in both its interpretation of what the statute requires and its policy with respect to these specific requests.
No further questions? Kept you up a little over the time. Thank you very much.
Thank you, Your Honors. We ask you to affirm.
Mr. Christensen, we'll get Christensen. I don't know if I said that correctly. I apologize. I'll give you 3 minutes.
I think it's important to keep in mind what is the alleged policy that the district court actually found. And that's on page 1868 of the appendix. The district court found that the IRS has made a final decision to adopt and implement a policy of disclosing the confidential address information of tens of thousands of taxpayers to ICE under section 6103 of the code in reliance on representations from ICE that the addresses are relevant to and will be used for immigration-related criminal investigations and proceedings, even when ICE identifies only a single ICE employee or small number of ICE employees as the employees personally and directly engaged in each of the tens of thousands of relevant criminal investigations or proceedings. That's the policy as the district court found it. And frankly, it's simply a gloss on the policy that's actually reflected in the memorandum of understanding. All of the evidence in the record about an address sharing policy is simply evidence of the address sharing policy reflected in the memorandum of understanding. Whether IRS processes these requests en masse or in bulk really is the sort of day-to-day operation that courts don't get involved in and that are not reviewable under the APA. It's a common management of government programs that courts just don't get involved in. And ICE doesn't have discretion to deny a request simply because it's made in bulk.
IRS, you mean?
Thank you so much. That is what I meant.
No, I think, correct, if you had the computer algorithm that could, in fact, make sure every jot and tittle of 6103I2 was satisfied, the fact that it could do it for 1,000, I mean, the statute itself, it seems to anticipate individualized considerations, but it was written a long time ago. Not that long, but written at a previous time before all this computerization. And that wouldn't be, there's nothing in here that insists that it has to be done one at a time, as long as Congress's requirements are satisfied.
Yeah, I agree, Your Honor. And it also, if I may, just quickly, with respect to standing, the center and organizational standing, the center argues, and the district court found that taxpayers were less willing to engage in its services. And those taxpayers included two specific groups, taxpayers with individual taxpayer identification numbers and taxpayers for whom English is a second language.
And domestic violence victims.
And that's in the statute, correct? I don't think the district court made that finding.
Oh, it was in the record here.
Okay. Yeah, I don't recall for certain. The point I wanted to make is that those groups of taxpayers simply are not a proxy for the individuals implicated here under the IRS's address sharing policy, which implicates individuals who have overstayed a final removal order. The district court didn't make any finding that the center's services provided to individuals who have overstayed a final removal order have decreased.
No, but the point is a chill point. It's a point that as never before, I mean, in most countries, I think you wouldn't go to one government bureaucracy and think you could trust it not to share information with another, but we have a very strong tradition with respect to the confidentiality of taxpayer information. So I think they're thinking, whoa, we thought there was kind of a wall here, but this is showing there isn't. Who knows what they're going to come after me about?
I guess with respect then, if that's the case, if it's the chilling effect, then again, that's a speculative chain of causation to tie to.
Given Department of Commerce, I think the notion that, I mean, people who are absolutely lawfully taken in the census, you know, if they start upping the requirements, people are going to be deterred.
The other point that I would make is you would expect, or you know, the predictable effect of the policy wouldn't be that taxpayers would be less inclined to seek services that are free, that are provided by the center. In fact, you would expect that the opposite would occur, that these immigrant taxpayers would actually be more interested and more inclined to seek out the center's services, which are provided for free, and where the center is dedicated to informing these taxpayers of their rights.
I can't have anything to do with the IRS. Why would I bother to go find out information? I already know this is a bad deal.
I mean, I think
it's crazy policy, you have to admit.
But that would be an irrational taxpayer to say, you know, I'm not going to file tax returns. I'm going to not comply with that without first going and seeking services from an organization like the center. So I think that it's a stretch or speculative to say that the address sharing policy caused these taxpayers to be less willing to engage the center's services. And finally, just to point out that under the Supreme Court's decision in Alliance, in order to establish standing under Havens, that the challenged action must, in the Supreme Court's words, must directly affect and interfere with the center's or the organization's core business activities. And here, under their own theory of injury, it's a remote theory of injury based on indirect causation, which if this court were to adopt that theory of injury, it would certainly be an expansion, or it would be extending the Havens holding, which Alliance tells us courts should not be doing.
Understood. Thanks.
Thank you, Your Honor.
Thank you very much to both counsel for all your assistance with this case. It is now submitted. The court will take a 5-minute break.
Case number 24-1384 et al., Preferred Building Services, Inc., petitioner versus National Labor Relations Board. Mr. Patel for the petitioner, Mr. Heller for the respondent, Ms. Johnson, the reader for respondent.
Good afternoon. Thank you for your patience.
Thank you.
Complicated cases today.
Good afternoon, Your Honors. May it please the court, Tyler Patco for the petitioner, Preferred Building Services. And I'd like to reserve 3 minutes for rebuttal, if I could. Thank you. So this appeal concerns the denial of constitutional due process rights. As the board and all parties agree, including the intervener, SEIU, if the picketers, they're sometimes called alleged discriminatees, if they were engaged in either recognitional picketing or secondary picketing, they lose the protection of the act. Everybody agrees.
Is that a constitutional issue?
Well, the exclusion of evidence is what I'm getting to, is the
Okay.
constitutional issue. So in this case, that principle was violated very early, 11 years ago at the trial. I was there. The judge, you give trial estimates. It's just like a federal trial. Federal rules of evidence apply. About the 6th day, we made a motion. Hey, the general counsel has taken way more than their allotted time. Their time estimate was 4 days. And the next morning we showed up and the judge issued sua sponte, an order striking all of my client's affirmative defenses. Not only that, preventing my client from presenting any evidence into support of those affirmative defenses. The first board got a limited record, and they found even on that limited record, there was sufficient evidence of secondary picketing, that is pressuring a neutral and meshing a neutral in the primary employer's dispute. That's unlawful. That's unprotected conduct. That was on an incomplete record. Unfortunately, that error, which is admitted, infected the proceedings all the way through, including in the Ninth Circuit, because in the Ninth Circuit looked at the board's decision and said there was insufficient evidence of secondary motive by the union in the picketing, but they had an incomplete record at that point. In fact, the evidence that was excluded by the ALJ would have shown the secondary picketing motive, because just like in the general maintenance case, 1999 decision by the board, there were trashing incidents at the Millennium Tower. That's a skyscraper in San Francisco. It's actually sinking, but it has very prominent tenants. One of the best quarterbacks ever, Joe Montana. They come in on Christmas Eve and throw coal into the lobby. They fight with a security guard. The San Francisco Police Department is called. They show up and they fill out a report. There was injuries at the picket line. That's exactly the kind of evidence, Your Honors, that was at issue in general maintenance.
So I guess to sort of move the camera forward a little bit, we're reviewing the board decision in round 2 here.
Yes, understood.
Board decision.
Yeah.
And that board decision said we will take as given your evidence, even accepting your evidence. We will take it.
Right.
It doesn't show secondary picketing because it occurred after the unfair labor practices at issue.
So if I could.
So your evidence got in, you provided that evidence. It was considered by the board. We can see it too. And they said,
Right.
post hoc rationale.
Right. Understood. Good. Excellent question, Your Honor. So the Ozark case, this court taught us that an offer of proof is not a substitute for live testimony. It's not cross-examination. I'm a trial lawyer, not really an appellate lawyer, and I love a good fight. I just don't like to fight with two hands tied behind my back, which is what happened.
Your job is your trial lawyer, your job is to make a proffer. Here's what we would have shown. Here's what we would have done.
Right.
And then when you come, we have sort of an equivalent rule here at the appellate level that you have to show prejudice. And your prejudice in your brief here is we wanted to put in the evidence about Millennium Tower and the trash throwing. And you don't say more that had we been allowed to cross-examine someone, we think they would have said, or you just said we wanted to be able to put in that evidence and the board considered it. So you're not prejudiced when they consider it and they say, it doesn't matter. It was long after the unfair labor practices and no amount of cross-examination is going to change the calendar.
I understand what the second board said. That's the reason for the appeal. So in that Ozark case, the court found an order barring a party from introducing relevant, non-cumulative evidence is typically always prejudicial and reversible. And the same applies here. The court said—
It's not relevant is the point. It's not relevant if it post-states all of the unfair labor practices.
Well, okay.
How is it, maybe that's where I'm not understanding things.
Right, right.
How is it relevant if it post-states
So
firings?
yeah, so the recognitional picketing 8B7, if you picket for more than 30 days without filing a petition, it's unlawful, it's unprotected. The Millennium was 57 days after the picketing started, so it's relevant to that, 8B7.
I didn't understand. I thought your argument about your due process argument was as to the secondary picketing.
As to both, Your Honor. I mean, it's relevant to both. The secondary, it's relevant because, again, the picketing—
Did you tell the board that we want this Millennium Tower thing to be considered as part of the recognitional picketing?
We wanted and what we thought we would get is a remand to present evidence, live testimony, call the tenants, that had coals thrown in their lobby and a security guard assaulted on Christmas Eve. That's what General Maintenance said is relevant. We were prevented, actively prevented. My client's president, Bob Squeary, it's a family business, this business he started. He started to testify after November 19, the union shut down 12 more sites. They picketed those sites as well. The judge cut them off. You can't go there. I'm not even going to let you go there. We were not allowed to present our evidence. That's why it's a due process issue.
So in your brief to this court, where do you argue your due process point about putting in evidence as the Millennium Incident as part of your argument about recognitional picketing?
Well, the recognitional picketing, it's relevant on its face.
I'm sorry, I asked you a question about where in your brief I can find this.
So, and
You said you've argued it as to both, and I think I must have misunderstood something.
well, it's relevant on its face. It's more than 30
It needs to
days.
be relevant it needs to be raised in your brief on appeals.
It is argued in our brief that it's relevant to both recognitional and
Maybe you
second.
can tell me on rebuttal. I won't make you
I'll find
read
it.
through it right now.
Yeah.
You can do that on rebuttal.
So again, this court in Ozark, not too long ago, 2015, there are sometimes errors at trial that deprive a litigant of the opportunity to present its version of the case. They are also ordinarily reversible since there is no way of evaluating whether or not the evidence affected the judgment. When, for example, an appellant has been deprived of the opportunity to summon witnesses, the appellate court—
You're not objecting to inability to conduct discovery. You knew what the evidence was you wanted to put in, right?
That's correct. And these.
That was described in the proffer of evidence.
We tried to describe it in the proffer. Some of it, until we talk to the witnesses and cross-examine the picketers, it's not even known what that's going to be. For example, the timing of the picketing on Christmas Eve at Millennium, whether that was after hours, whether it.
But it's a little bit like summary judgment. Summary judgment is not a due process violation, or, even though you have to reduce evidence that, in live form might be more or differently expressive. A proffer is like, you have to say what it is that you wanted to put in. And to the extent that it wasn't fully descriptive, I don't think that's a reason to reverse.
Well, we did describe the evidence.
Yeah. And the court said, yeah, okay, we hear it, we see that evidence, we accept it.
Right.
But if it were brought in, it wouldn't make a difference to us.
Yes.
So the refusal of the evidence, I guess, isn't really a due process problem. It relates to some other legal error that you'd have to identify.
Well, again, I think it is legal error to deny the party an opportunity to call witnesses. And armed with the evidence that we should have had at trial to use cross-examination skills, Ozark says that as experienced trial lawyers know, when a hostile witness realizes that an examining counsel has information bearing on the answers to counsel's question, the witness tends to be more candid. Here, the company was deprived of this incentive for truthful and complete testimony. In other words,
Are you aware, what's your best case that your hope, and I will take as given that you're an effective examiner and cross-examiner, your hope that through the crucible of cross-examination, something would be disclosed that would undermine either the secondary or exceptional picking thing. That's just the hope that the process itself, you're not making a proffer as to that.
right.
That itself is required by due process.
So I'm going to make
Or legal error in any way. I don't understand that error. We require people to show how things are going to work out, not speculate as to cross-examination.
Understood. So I would make an analogy to an employment discrimination case. No employer is going to say, hey, we discriminated, right? We discriminated based on age. We terminated all the people with higher salaries, which correlates to age. So we have this burden shifting pretext, circumstantial evidence, the totality of evidence is considered. It's the same here. We're evaluating the unions, the picketers' motives, their subjective motives. Why were you picketing? Well, they said why. We want a union. That's recognitional, as Member Kaplan found. That was recognitional in nature. But I wanted to point out that this issue of primary versus secondary is very nuanced. It's very, as the board has said, it's among the labor laws most intricate. It's based on the overall impression of what the parties were doing. And when you limit the evidence, it doesn't allow the fact finder to know what the totality of circumstances were.
I guess in this circumstances, but general maintenance relied upon was actually the absence of the employer from the site, right? That's one of the factors. The absence of the employer from the site. And you've made no proffer that Preferred Building Services was present on December 24th, working in the building. And you don't need cross-examination for that. You represent Preferred Building. And so without having made that proffer that you actually met the prongs of the recognitional picketing issue,
So
that information is entirely within your control.
well,
Is that not a problem?
So general maintenance considers a number of factors to go into evaluating, just like employment discrimination, circumstantial evidence. Did the employer have shifting reasons? Was there other evidence to suggest a bad
I'm
motive?
just asking a question, this one. Okay, general maintenance, case you've invoked,
Yeah,
went off on the fact that there was no evidence that the employer was present at the site, one of the required prongs for something to count as recognitional picketing. And your proffer nowhere mentions that Preferred Building was in fact present at the site on December 24th.
so,
When this picketing happened.
so,
You can't win without that showing, and you haven't made it.
That's not what general maintenance says. It's one factor among many.
Is it an optional one?
No,
Because a couple of factors are all about, it's the site, they're at the site, this is the time when they'd be at the site.
Yeah,
That's pretty important.
That's all more dry dock, and in general maintenance, what the court focused on was the trashing. And
No, I think the court, it's legal. rule. I think this is what the board said here was that the employer wasn't there. You can't be, right? The employer has to be there.
Well, that's a factor for the dry more
dry dock.
but there's many other factors that go into it though. And Concede Preferred was there. That was their building. They were cleaning. That was one of their contracts.
They have
Just
to
like
be there at the time of the picket on December 24th.
And let's assume they were. I'm conceding that they were. You can't.
No, that they were or were not there.
They were there. They
No,
were
you
there.
don't get to concede that. You didn't proffer that.
No, I'm saying for purposes of argument, we were there.
No, not there. Let's assume they're not there.
Well, then again, that is evidence of secondary pressure if the employer was not there, the primary employer was not there. So it's one of the factors. I mean, general maintenance.
Sorry, I keep getting confused whether you're talking about the recognitional or secondary picketing issue.
Yeah.
I thought you were on recognitional. Okay.
I'm sorry, we're kind of skipping back and forth, but either one is a prohibited picketing, a prohibited objective.
Which time was this picket?
So there's a series of them, Your Honor.
The one on December 24th at Millennium Tower.
And that was all excluded. So October 29th, they started.
No. I'm asking just from your proffer, the evidence you wanted to get in, the evidence you asked the board to do a remand for.
Yeah, it was.
What time was it on December 24th?
It was Christmas Eve.
What time?
I don't know the exact time it was.
Morning, midday, afternoon, evening?
I think it was the evening. I know.
Evening, okay.
Yeah, I know that there was police were called. There's a police report that we were prepared to introduce, but
There was a security guard.
yeah, there was
No proffer that there was anybody in the building Christmas Eve evening other than the security.
Well, I mean,
Is that relevant?
I don't think our burden on appeal is to identify every scrap of evidence that we would have mustered and presented if we had been given the opportunity. When the judge said, you can't go there, I'm going to cut your witnesses
I'm
off.
going with where the board went. Okay, you went to the board. Board decides everything, reviews de novo. It can decide anything. It can decide facts de novo. So when you go to the board, you know this. You want to go up and tell them, here's what we weren't allowed to put in. We got to make a proffer. And if your proffer didn't include the things that made your proffer, with the exclusion of that evidence legally relevant, then then they're fine to say you haven't shown any prejudicial error.
Yeah, well, we didn't have witness declarations, for example. We were given a limited time to prepare a proffer, which we did. And we mentioned the police report.
I know, but a police report, what you didn't mention was anybody in the building?
Well, the police were called to because there was violence on the picket line.
Or a security guard, yes. That doesn't mean that there's other businesses in the building were there and were harassed.
So it's a 40-hour
Christmas Eve evening.
Right. So that there's no question the police were
40
called.
floors and you're not even going to know what's going on the ground floor. But
yeah,
I'm just getting to the point that you had an obligation to show things here. And you picked Millennium Towers, you picked the police report. But it doesn't seem to me that you were meeting sort of the legal prongs. And if you want to talk about secondary picketing or recognitional picketing, that you would have needed for the exclusion of that evidence to be prejudicial. But I guess, and I take it your argument as well, we would get more information if allowed to go put it on before the ALJ. Is that your answer?
That in part, I mean, we would be allowed to cross-examine the picketers, for example, which we were prevented from. The evidence shows at Millennium, they threw coal into a residential building lobby at members of the building security team, causing physical injuries, resulting in a police report. The ALJ said that was not relevant. It's not, I'm going to exclude it. It was only by luck that we got that into the record because the judge excluded everything. We did include that in our offer.
By luck, it was you doing your job for the board, right?
Well, we did include that in our offer of proof. There was also testimony by the union that They visited about 20 sites where Preferred had cleaning contracts. That's at 1J80 and 1J102. Mr. Squeary, the president, testified that SEIU targeted at least a dozen other sites after November 19, and that Preferred lost contracts as a result of the picketing. It was coercive in nature. We didn't, to your point, Your Honor, we didn't go through and do pages and pages of what we would eventually introduce if given the opportunity. The first boards made it so that we didn't have to go there. They decided just on the limited record there was sufficient evidence. And honestly, we thought we would at least have a hearing to be able to present the evidence that we were excluded, to cross-examine their witnesses, armed with this evidence that we could use. Clearly relevant, as the board found, and it was just the error infected the entire proceeding.
I think we're a bit over your time. Do you have any questions? Any questions? We'll give you some time for rebuttal.
Okay, thank you, Your Honor.
Good afternoon. May it please the court. Joel Heller for the National Labor Relations Board. Preferred does not dispute that it discharged, threatened, interrogated, and surveilled employees who were picketing to improve their working conditions. And substantial evidence supports the board's finding that Preferred failed to make out its affirmative defense that those employees were engaged in either secondary or recognitional picketing. So Preferred's primary argument on appeal is an evidentiary one. But there's two problems for Preferred in its argument that it should have had the opportunity to introduce additional evidence. As the court has been over already, one is that the board already considered the evidence, considered whether that evidence would have demonstrated a secondary impact, and determined that it would not. So there's no prejudice. The second problem is that, as we were discussing before, that evidence is not relevant because it only went to the December 24th demonstration at Millennium Towers. As you were saying, Judge Millett, that December 24th postdated all of the unfair labor practices in this case. So even if Preferred had been able to show a secondary object on December 24th, that would not serve as an affirmative defense to actions it had already taken by that point. And even if the December 24th demonstration were relevant to the even if Preferred's argument is that the December 24th, it would introduce evidence about the December 24th demonstration vis-a-vis its recognitional object defense, it's the same problem because the board already found that there is no evidence of a recognitional purpose, and that's a substantial evidence question at any of the demonstrations. These, in its offer of proof, Preferred said that the 1224 demonstration had the same flyers with a similar message as the October and the November demonstrations. That's at JA 1969 through 70. And the Ninth Circuit already determined that that's the secondary versus primary. The Ninth Circuit already determined that those flyers were primary in nature. And the board, looking at the evidence in the record, also determined that there was no recognitional purpose. And so there's no recognitional purpose evidenced in these flyers in the messages that were at October and November. Therefore, since it was the same in December, there was no recognitional purpose in December as well.
Why is we want a union,
Sure.
not evidence of recognitional or
Right.
maybe this was organizational picketing?
Sure. So two things. One is that the chant, well, that wasn't the completion. That wasn't the complete chant. It said, we want a union, not corruption.
We want the union. Was it the union? Maybe it was whatever.
I don't remember if it was a
union.
Yes,
Right.
not corruption.
Okay.
So it's,
Well,
yeah. So you look at the context, you look at the totality of the circumstances, what else was going on at these demonstrations. So yes, in that one chant, there was reference to a union. There were other chants that didn't reference a
lots
union.
of SEIU signs.
Some of the signs had SEIU on them, some of them didn't.
Okay.
You had the flyers, that the handbills that were passed out, those did not mention unions. So right, there was some indication, there were some references to unions, but not everything was referencing unions. And even the references to unions, just because there is a reference to, or just because a union is on the scene does not necessarily make it recognitional in nature. And again, looking at the totality of the circumstances, at the context, the focus of these demonstrations were on the working conditions at preferred contracted buildings, the sexual harassment, the hours, the wages, those kind of things. And the union was helping them out. Local 87 was helping these employees address those issues. And that doesn't, however, make it a recognitional, an unlawful recognitional purpose. Because you look at, sometimes we say these words, recognitional purpose, organizational purpose, as shorthand. But look to the text of 8B7 and what it says. What is improper recognitional organizational purpose is when the picketing has the object of forcing or requiring an employer to recognize the union, or forcing or requiring the employees to accept a union. So a reference to a union, or even saying some of the employees saying they want a union, doesn't get to that level of forcing or requiring recognition of that union by an employer, or forcing or requiring other employees to join up with that union. But so those were kind of hitting the point where it is, but to make a bigger point about the "we want a union" line, sure. Preferred has another way to interpret that evidence. They think it shows a recognitional purpose. But ultimately, just because Preferred has its own interpretation of the facts isn't enough to displace a board decision on substantial evidence review.
It's a test, the question, I guess, for what the object of picketing is it an objective or subjective test?
Right. I think you're looking at objective factors because especially on the recognitional point, you're looking at it from the perspective, I would say, of what an employer or other employees would think, because that's that kind of forcing and requiring the impact on those other parties. And so you're looking at what was said out loud, what was broadcast to the employers or to other employees. And that is more objective in nature, I would say. And sorry, the other point on that is, right, so then is it just a legal question? Or is it a factual question what the object is? It has been treated as a factual question.
Even if it's an objective test?
Right.
Of what sort of a reasonable employer / employee would think?
I think so. I think this court has certainly applied it has applied the substantial evidence standard of review. I don't remember if offhand it specifically said it's a question of fact, but it has said substantial evidence review applies here. Other courts.
It has to be a fact question if it's a substantial evidence question, right?
Yes, a question of fact.
What would a reasonable person in the context think? And you're asking the jurors to make, reasonableness sometimes can be legal, sometimes factual.
Okay.
And you're saying here it's factual.
Right. That is how this court has
Would a reasonable employer here feel like they were being pressured into having a union? Would a reasonable body of co-employees feel like they were being pressured to ask for a union?
I think that's right. I don't think it's about kind of what in its heart of heart Local 87 wants to happen. Because looking at the language in 8B7, where it's talking about forcing or requiring, it's not talking about does the union hope that these employees will join up with the union at some point. One other point I would say on the evidentiary point, which was the bulk of Preferred's argument here. So we've been over why the evidence in their proffer is insufficient. They say, well, they speculate that there would have been some additional evidence that might have come in on cross-examination. But the court's standard when reviewing these evidentiary issues is whether it clearly appears that the new evidence would compel or persuade to a contrary result. And the only way the court can answer that question is if it knows or at least has some indication of what that additional evidence would be. And Preferred doesn't offer any of that. That's why in Salem Hospital
We are
Court.
hampered here. The upfront decision of the ALJ a couple of rounds ago.
Right.
To just flat out exclude their affirmative defenses. Is that defensible?
So I know that the ALJ did make that point about excluding evidence, but the ALJ also did address their defense on the merits. So it's not that the ALJ entirely excluded everything that has to do with these affirmative defenses.
Well, it's kind of saying, I'm not going to let you put your evidence in, but now I'm going to address your claims. seems
Right, I'll admit that that was a little odd. But again,
odd. Is it right? Is it wrong? Are you defending that?
I'm not defending here the ALJ's initial decision for the reason I think you said, because what's on review now is the board's decision. And the board decision saying in response to their request to reopen the record was to say, well, we've looked at it essentially. So you could essentially say, even if the ALJ.
Fruit of the poisonous tree here. It's like, all right, we told you sort of a grand briefing level what we wanted to get in, but because of this upfront error, it just left the record bare, and we can't obviously create on round two before the board every jot and tittle of what are allowing us to put on the evidence of our affirmative defenses would have exposed.
Sure, it's not every jot and tittle, but they have to do something. And what all of they've specifically identified is this December 24th incident at Millennium Towers. And we've already talked about that. They haven't said whatever else they want to put in. And in the Salem Hospital Corp., the NLRB case that they cite in their reply brief, this court said that when an employer or a party fails to provide specific evidence of potential witnesses' testimony, we cannot determine that the excluded evidence was either relevant or material, much less how that testimony could persuade to a contrary result. So the preferred hasn't given the court anything by which to make the determination that there has been an abuse of discretion, that there would have been a different result had they been able to put in additional evidence post-remand.
On the secondary picketing,
Yes.
if it was a matter of law that, since it postdated all of the unfair labor practices, December 24th, the evidence by December 24th, if that were the basis for upholding the board's decision, could they then raise this issue again at compliance proceedings?
Well, at that
Secondary picketing and say, as sort of a unclean hands? And the same question for recognitional picketing.
Right. So it wouldn't go to the liability question at all. The question of whether they could bring it up on compliance is whether like the.
Pretty equitable-ish proceeding if they just sort of said unclean hands.
But so what, I guess, what would they be making that argument in purpose of? That there was like
I'm just
cutting off of back pay or something like that? I mean, that would be a question.
would want to hire them after they threw coal at security officials on Christmas Eve. You can't make us hire people who violate criminal laws. I mean, I don't want to make their arguments for them.
Right.
Probably got way more sophisticated ones than I'm thinking. I'm just asking, I'm trying to understand how this liability and compliance proceeding things.
Sure.
To different ways of
Right.
addressing this matter. They could show later.
Yes. I think if the court rules solely on the timing issue, if they say the December 24th, we're not going to even look about whether that was secondary or whatever, we're just going to say it was too late. That is the sole basis for the court's decision. Then I think there might be some questions open on compliance proceeding as to whether that subsequent, post-discharge actions has some impact on the remedy. Certainly not saying at this point that they would be successful, but they could raise those arguments. So same with the recognitional picketing, because the recognitional picketing, if I could just explain this, that also has a timing problem for them, because the recognitional picketing is only unlawful if it extends more than 30 days. And most of the unfair labor practices in this case occurred before the end of that 30-day period. So the 30 days started on October 29th. Most of the unfair labor practices occurred within that initial 30-day period. So even if it was recognitional picketing,
Seems
and I'll get to that.
an important word.
And I will get to that. But that's my first point. So even if it was recognitional in that first 30 days, it's still lawful. So that was most. As to the rest of the unfair labor practices that occurred after the 30 days, they still occurred before there was any additional demonstrations. So after November 17th, I believe it was, the next demonstration was on December the 18th. So that was the first picketing that was outside of the 30-day period. But all of the unfair labor practices had occurred before December the 18th. So even if December 18th, December 24th was recognitional, outside of the 30 days, all of the unfair labor practices had already happened there. So they face the same timing issue as they do with their secondary.
What about the ones that were outside that initial 30-day period?
Yeah.
Call it the protected period. there were some that were out, but I thought they were terminations that were because of the contracts
Yes.
canceled, which were canceled within the projected 30-day period.
That's true. And so if you take it in that way, then everything occurred in the
Well, is
initial
that right
30-day
or wrong
period.
way to take it?
I don't think it matters because the timing is bad for them either way.
Right, just because I asked the question, is that the right way or the wrong way to take it?
So I guess you could say that the
What does the law say about that? If you terminate a contract this period, but then you don't effectuate the
Right.
terminations of the individuals, the only, let's assume it's a clean, clear decision that was only
Right.
because of the contract cancellation. When does that mean the the relevant unfair labor practice happened?
that I don't know. Not an issue that has been briefed. It was not raised by the other side, so I don't have an answer for you on that point. But again, I think it doesn't actually matter under the facts of this case, because either if you say, well, that happened when the contract was canceled in mid-November, or it happened when they were actually discharged in December 14th and 15th, it was still before any purportedly unlawful recognitional picketing. So because the unfair labor practices are on their merits undisputed, and because the affirmative defenses fail, the court should enforce the court's order.
Any questions?
I don't think so.
Any questions?
No.
Thank you very much, counsel. Okay, so we'll hear from the intervener now.
May it please the court, Bryn Johnson for intervener, SEIU Local 87. The 8 workers who were discharged have now been waiting more than 11 years for their remedy. Preferred's appeal doesn't contest the board's finding that those workers were fired for their participation in the protests and in order to chill further protests. The board was right not to reopen the record because the only evidence that Preferred seeks to put in is irrelevant to the remaining questions in the case. Because that evidence that Preferred proffered in its proffer to the board was only about the Christmas Eve protest.
Why were the workers chanting, "We want a union," if not for a recognitional purpose?
Yes, the workers were chanting, "We want a union, not corruption," and they were comparing the help that they had received from the union with the exploitation and the corruption that they felt like they were facing from the employer, as evidenced by the rest of the signs and the flyers in that case that were all expressing the workers' concerns with their working conditions.
And on the publicity proviso issue, if the workers were informing the public they lacked a union, then is the protest automatically recognitional subject to the proviso, or can we still conclude the protest fell outside of 8B7?
No, you could still decide that the protest fell outside of AP7 because we want a union while accurately informing the public that the workers did not have a union doesn't necessarily indicate that the purpose of the protest was to force or coerce the employer in order to recognize a union for the workers. There was none of the traditional evidence of recognitional object present in this case. The union never made a demand for recognition or tendered a contract. Workers weren't asked to join the union.
All they did was walk around with signs that says, "We want the union." And that's all they chanted is, "We want the union." That's the only thing happening. Would your position still be that it wasn't organizational or recognitional?
If all the workers did was have the sign saying, "We want a union," and chanted, "We want a union," then I think it could be a reasonable conclusion that they did have a recognitional object. However, that is.
You don't have to have those other formal processes for it to have. You talked about there's no petitions filed, none of those things. So you don't have to have those things, just the content of the demonstration itself can make it
It could.
recognitional.
Yes, that could be a finding that an ALJ could make that would be reasonable. However, that's absolutely not the evidence that is in the record here, in that the workers did not have any signs asking for a union. Their flyers and signs didn't mention asking for a union at all. And they weren't just chanting, "We want a
The union's
union."
name on a lot of them. in big
The
print.
union name was on there because the union was present, but it's well established that the mere fact that a union is present at a picket does not make it an organizational picket. Otherwise, the union could never have pickets at employers. They don't represent workers. But getting back to the chants, the workers weren't just chanting, "We want a union." They were chanting, "We want a union, not corruption," and many other chants as well that were all focused on their labor dispute with Preferred, including the Preferred buildings managers exploit workers. "We want justice. When do we want it? Now." So the overall context, and this is a totality of the circumstances consideration, shows that the workers' purpose of their protest was to highlight their labor dispute with Preferred. And the board reasonably found that. And because that's a reasonable interpretation of the evidence, that's all the court needs to decide this appeal, even if there are other reasonable interpretations. Judge Millett.
Why wouldn't the easiest way to sort of integrate all of the communications to say they were opposing these various unfair labor practices and they wanted a union because they had not been successfully able on their own by rebuffing the advances of the supervisor and the like to stop the practices? And it just seems like a natural way to read it is, yeah, we're opposed to this and this and this concrete thing. We want more money. We don't want to be harassed. To that end, we want a union.
No, I don't think that would be the correct conclusion to draw in this case because the NLRB expressly found, and there was testimony in the record by the workers and the union president about what the communications between them were. There was no testimony that the workers asked to join the union or asked the union to represent them, or that the union indicated that it was trying to represent the workers. The NLRB found in page 12 at the end of footnote 19 that there was no evidence that the employees were seeking recognition or to be organized, or even that the union was attempt to organize them at that time. I believe I've used my 3 minutes unless there are any other questions.
Good. Any questions? All right, thank you very much, Council. I will give you Mr. Is
Paitko, tough last name. Thank you.
Mine always gets mispronounced. Okay, I apologize.
No problem.
We'll give you 2 minutes.
Thank you. So just to start, because it's an easy answer, the statute answers your question whether you can go back and the prior picketing is insulated. If it's recognitional, the failure to file a petition after 30 days renders the entire period unlawful, unprotected. So it goes back to the day that they started.
The statute is pretty confusing in its language. What language do you think?
29.
Said it so explicitly.
Yeah, it's in our brief at page 8 in our reply.
No, I'd like to let's look at the statute.
29 USC section
158.
158B7. Yeah.
All right. So where's the language there that says it vitiates the whole thing?
The entire period of picketing.
Where does it say that? What language exactly? Can you read the statutory language? 158. Sorry, this is recognition. So on B7. Yeah, so B7. What language are you relying on that says that it vitiates the entire period?
That's my reading of it. You don't get a pass.
Where such picketing has been conducted without a petition under section 159C of this title being filed within a reasonable period not to exceed 30 days from the commencement of such picketing. But the difficulty there is you said it textually, the statute vitiated it. I find the language somewhat ambiguous in that regard.
I would, if I could submit another brief on it. It's been established law that if the picketing is recognitional, it goes back to the original date.
What established? Where's that established?
Well, it's in the statute. I mean, in any case.
I'm asking you the statute. So the statutory text here does not say that it vitiates anything that went before as I read it.
Failure to file petition after 30 days renders the entire period of picketing unprotected.
Is that in the statute? I'm sorry, I'm not seeing that.
That's my.
So what's your site? Sorry. Did you find it? Do you have a site
Yeah, I'm citing our brief, which is a paraphrase, but
That's
that's,
the problem with the paraphrase. Okay,
yeah, I
so
understand.
I'm
But
looking at the statute itself now. Do you have a copy of the statute with you?
It's in the red brief at Romanet 1 and 2 at the end, addendum.
Thank you, Your Honor. So yeah, the start of this section, unfair labor practice by labor organization, that's in B. And then it lists these things. It's an unfair labor practice to do any of
You
these
want to go to
things.
number 7.
And
Picket or cause to be picketed an employer where the object is forcing or requiring the employer to recognize or bargain with a labor organization
so that,
unless labor organization is currently certified as a representative.
It's unlawful. I think you want to go down to C, where such picketing has been conducted without a petition of this title being filed within a reasonable period of time not to exceed 30 days from the commencement of such picketing.
right, it doesn't, I guess the better way to say it, it doesn't provide an exception that if your original picketing was lawful and your later picketing is unlawful, there's no violation. What this statute says, you can't engage in picketing for a recognitional object or secondary object, putting pressure on a radio station, the tenants in the building that have nothing to do with the dispute, and enmeshing them in the dispute. That's the secondary boycott picketing prohibition. But either way, if it's secondary or recognitional, these are tough issues. That's the point of developing a full record. On an incomplete record without adequate cost cross-examination, that's what Ozark said. The offer of proof is not a substitute for live testimony and cross-examination. And just on the organizational, we want a union. There couldn't be anything more recognitional than that. The president of the union, Mr. Miranda, Olga Miranda said.
Dispute that it's the totality of the circumstances test.
No, I do agree, but that's a big one. We want a union. How could that be anything? As member Kaplan said, Chair Kaplan said, that is the epitome of a recognitional cry. It's an organizing cry. We want a union. How could you say it any more clear than that?
So how many have to say it how many times?
I don't think the law says, but the president.
Well, I mean, I think you would agree if they were out there for a couple hours and.
You can watch the video.
One person said.
They were chanting.
I'm asking a legal question here because you said you can't, that's the epitome. You can't get any more important than that. But if one person said it once in a 2-hour picket and no one else did, that wouldn't matter so much, right?
Yeah, I would agree, Your Honor, with that. If it was just what they were chanting it throughout, and it's on video. It's submitted. It's in evidence in the record.
It wasn't everybody.
Well, the alleged discriminatees, the picketers, were chanting that. We want a union. We want a union.
All of them said that? All of them are on video saying that?
All of them on the video that are making the chant. It's multiple people. I didn't go through and say, oh, did this person sit out? I mean, it was a group demonstration, noisy. They were all chanting the same thing. We want a union. We want a union. We want to be recognized. Right. Not down. And that doesn't change it. I mean, we want our union. Well, the president of the union said they're organizing our workers that we're organizing, our members.
So this is a fact question, I think. Do you dispute that this is a fact question? But we asked whether the object of the picketing is a fact question.
Well, I'm saying.
I'm sorry, do you agree that it's a fact question, what the object of the picketing was?
Absolutely. I do agree with that.
Right.
I just think.
The circumstances fact
Right,
question.
right.
So what you have to show is not that one could watch that video and come to that exact conclusion,
Well,
but that it was clear error or the equivalent of that super deferential review of fact finding by this court.
I understand your point, Your Honor, but I'm not here to retry the case, to re-argue the machinations of with the secondary. The point is due process. Give me a chance. Let me call my witnesses. Let me bring in my evidence. And the totality of evidence is all relevant. Including, what Member Kaplan, then Chair, said, only the picketers would understand the gravamen of what they were truly communicating, not the public. They would not be apparent to the public that the employees were not represented by the union. That's why the publicity proviso does not apply here. And just one other thing I wanted to mention that's in the record that I forgot to mention in terms of what evidence would be provided. There's also evidence in the first board decision, footnotes 3, 11, and 12. The judge.
Well, but that decision's been vacated?
Right. This is evidence that was excluded. The judge refused to admit evidence regarding, among other things, why the leaflets were drafted as they were and whether the picketers blocked access to the building. In other words, evidence that would have shown secondary activity, coercive activity towards the tenants. And that's what the Ninth Circuit said when it talked about general maintenance. It said the reaction of the tenants was relevant evidence because the union directly targeted the building's tenants and owners with coercive activity. And here, in contrast, they're talking about the preferred case. There was the union never engaged in coercive conduct targeting Harvest or any of the building's tenants. That's what they did at Millennium. It worked in the first building. Let's go to the next one and let's ramp it up. Let's commit violence.
Way over your rebuttal time here.
I appreciate the time, Your Honor.
All right. Any more questions? No. All right. Thank you to both counsel. The case is submitted.
This honorable court still is adjourned for Thursday. You can go to that next Thursday.